in my experience, but it's different in Okaloosa County or in this?
Yes, Your Honor. Sometimes you'll hear the announcement of 6:15 instead of 5:15. And in that case, it would be, but we try to parcel it out.
Got it. And, ma'am, you'll be obligated to pay a $150, your public defender application fee is $50 and a $100 public defender fee. There'll be, we have two different dates of arrest here. Did the clerk do two appointments of counsel, or was counsel appointed at the same time on both cases? Right.
They only get a trade.
Okay. So you'll pay a single application fee and then $100 per case of attorney's fees. You do have the right to a hearing about whether the fees are reasonable. Do you need a hearing about whether those fees are reasonable or not?
No, sir.
All right. I'll find you've waived your right to a reasonable attorney fee hearing. And you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. Counsel, have I overlooked anything that I should have included?
I think that's it.
All right. Thank you. Ladies, any questions?
Your Honor, Charles Berry was state probation. Due to the fact that she's going to have to go to counseling and be responsible for that fee, and the fact that she has been deemed indigent by the court by the appointment of the public defender, we request the supervision fees be waived to assist her in able to successfully complete.
Request is granted.
And I have one other matter, Your Honor,
Yes, ma'am.
if I may address it.
On case, please.
Yes. Savannah Matthews is present and approaching. Ms. Matthews is here today. We're here today in 22 CF 1077. It's a VOP. And Your Honor, we are in negotiations with the state, and I don't believe there's an objection. We're going to continue it to the next miscellaneous date, which is February 28th.
No objection.
All right. And Ms. Matthews, do you have any objection?
No, sir.
All right. And as presume this is a fairly new probation, so in the meantime, stay in touch with your probation officer. If you have any uncompleted tasks that need to be satisfied, if you have the ability to do so between now and the next date, do it. Let your probation officer and your attorney know about it, and that may make a difference in the outcome of your case. Okay? Any questions? Thank you.
And that's all I have
Please.
today, Your Honor. May I be excused?
What is the date, please? Thank you. Yes, ma'am. You're excused.
Thank you.
Good morning, Your Honor. Lisa Rivers with and on behalf of Rosemarie Patricelli, 18 CF 86, 19 CF 214. Your Honor, she was arrested and put on this docket for violation of probation. No violation of probation has been filed. I spoke with probation. She has not been put on probation yet. This is a violation of some DOC requirements. So we will be asking the court to dismiss this violation of probation at this time.
And Your Honor, Christine Boss, on behalf of the state, we did confirm this with probation and parole with Mr. Harris, that this is actually a parole violation. Therefore, we are asking that the VOP be dismissed at this time. She's not anticipated to go on probation, I believe, until April 3rd.
I have an indication in the clerk's docket that VOP warrant status changed to served. There's a docket entry in that regard, but I don't see, at least in my quick inspection here, a copy of that warrant or affidavit. So, but by agreement of the parties, does the clerk agree there is not an actual affidavit or warrant here?
Your Honor, Charles Berry with state probation. This is a case of her being on a addiction recovery release program from prison. Violated that by using or testing positive. The probation has not began until she finishes the
I'm just trying to clarify some docket entry here, issues here.
You look good, by the way.
Thank you.
And this is on both cases?
Yes, Your Honor.
Okay. Ma'am, is your name Petrocelli or Petrocelli?
Petrocelli.
Okay. I was thinking that was the case because I didn't actually see an actual document, just the docket entry that those things had happened. At any rate, it is agreed by counsel and probation that you're still under the custody of DOC. That's an administrative issue about any violations of your participation in DOC programs. So violation probation allegation is, since technically, how should that be handled, ladies? Technically, there's not one here.
There's not one.
I'll just find that it's moot.
Yes,
as
Your
no
Honor.
supporting documents were ever filed.
Yes, Your Honor.
Thank you, Your Honor.
That's
That's what. So I just have to wait for Florida? Mm-hmm. And then, so.
Your Honor, Lisa Rivers or Kevin Allen Rogers were before the court on a bond reduction motion. Mr. Rogers was charged with written threats to kill or do bodily harm. His bond was set at $100,000. The state also filed unlawful use of two-way communication device to facilitate the commission of a felony, direct issue, no capias. Mr. Rogers is asking the court to reduce his $100,000 bond. It is so excessive that he is simply unable to make such a high bond. He has lived in Baker for many years. He has livestock that are in need of food and care, an elderly mother. He also has concerns about people looting his property when he's not there, because it's happened before. He's asking the court to consider setting a bond of no more than $3,000, cash or professional.
Do you have any witnesses either party wish to present? The state?
No witnesses, Your Honor. State just has
Defense?
argument.
Defense wish to call anyone,
No, Your Honor.
including your client?
Correct, Your Honor.
All right. And in the absence of any evidence, what's the state's position?
Your Honor, the state's objecting to a bond reduction. Now he's charged with a second count. I did not ask for a capias on that, so that does not have a bond attached to it. The state would argue this defendant is a flight risk. He's also a danger to the victim. He and the victim have a history of domestic violence. There's 3 prior cases he was convicted of involving the same victim from 2021 and 2022. There's 3 of those cases. This is the 4th case. He does score 30 months in prison. He has a string of prior convictions, including prior to failed to appear. He's been convicted of that. He has a prior escape charge. He's been convicted of that. He also has priors that include theft of grand theft, stealing of stolen property, resisting without violence, battery, assault, other crimes of dishonesty, drug controlled substances, sale and manufacture, possess with intent to sell and manufacture, deliver controlled substance, carrying a concealed weapon, battery upon a person 65 years or older, felony battery, fleeing or attempting to elude a law enforcement officer with lights and sirens activated, and other miscellaneous misdemeanor charges. Based on his criminal history with the victim, the serious nature of the offenses, and the flight risk, the state would ask that, Your Honor, deny the bond reduction request.
Counsel,
Your Honor, my client would like to respond.
present testimony?
Yes, Your Honor. He's saying now he would, based on some of the things that she has said.
Sir, I do want to mention to you, you have the right to testify here if you choose, but if you say anything that's incriminating, could be used against you. Do you understand that?
Yes, Your Honor.
And have you had a chance to consult with him about whether he should testify or not?
Yes, Your Honor. And would you please state your name for the
Hang on a
record?
moment.
Go ahead.
Raise your right hand to be sworn, sir. You swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
Would you please state your name for the record?
Kevin Rogers.
Mr. Rogers, you heard a number of the crimes that the state has alleged that you have committed. Do you agree with some of those things that she's alleging?
Maybe a few of them, but not all of them.
So you are disputing some of the things
A lot of
that
them.
she's listing?
Yes.
Okay. And do you believe that you are a flight risk?
No, I've lived here my whole life.
Okay.
I've lived here my whole life.
And is it your understanding or belief that you've ever been convicted of a prior charge, the same type of charge involving this
Never.
lady?
No.
All right, that's all I have, Your Honor.
Any questions?
Yeah, Mr. Rogers, have you ever been convicted of failure to appear in court?
Convicted of it?
Have you ever failed to appear for court?
To appear for court? Probably. I think, but I was like 20 years old.
Have you ever been
19.
convicted of a battery against the same victim in
Convicted,
this
no.
case? Have you ever been charged with and sentenced to a charge involving this victim?
They dropped it to a misdemeanor.
Yes or
It
no?
was dropped to a misdemeanor
So
for
yes?
7, I guess, if that's what you call it. But it's because I didn't wait it out because I wanted to get out. I would have beat that. I'm saying this woman came all the way from.
No other
Okay,
questions?
Don't talk about facts.
But I-
Don't talk about facts.
I'm not a threat to her. I'm not a threat to nobody. Just happened on my land.
Anything else, counsel?
No, Your Honor.
And state's argument again. Anything else with?
No,
based
Your
on that?
Honor.
Defense counsel?
Your Honor, again, $100,000 is excessive for this particular type of charge. He is unable to make any type of substantial bond. We're asking the court to consider no more than $3,000 cash professional.
Well, considering the record of involvement between these parties, I'm going to grant the motion for bond reduction, set bond on count 1 at $25,000, cash professional, count 2, $5,000. Condition the bond is no contact whatsoever with the alleged victim in the case. That's Tammy Jean Paul. And if you violate this restriction, your bond could be revoked and no bond warrant issued, and you'd be in jail until the case is resolved. Sir, do you understand that? Now, if she comes anywhere near you or tries to contact you, you should cut off contact without saying a word, without gesturing to her. If you see her on the street, just turn away, leave her. You do nothing to interact with this lady.
Yes, sir.
You understand that?
Yes, Your Honor.
Even if she initiates it. Certainly, you should not initiate any contact. That's the whole point. All right. And the returnable date, please. Stay in touch with your attorney, sir. Who is next, please? This Mr. Schroeder.
Okay, the only thing we've got here that they've charged you with by information is the possession of controlled substance, possession less than 20 grams, and possession of paraphernalia.
Yeah, see, they came back.
Do you want to continue this and we'll just check into this more?
Do it all right now.
Yeah, because this is the only thing I see out there. Okay.
I figure
well,
if it's up there, he'll see it too.
Yeah, that's true.
'Cause if I don't get out
Your Honor, before the court is Eric Schroeder Jr. on 23 CF 137. He is charged with possession of controlled substance, possession of marijuana, and possession of paraphernalia. We have reached an agreement in this matter. If I may approach the court, the agreement, Your Honor, would be for court costs of $515, $100 cost of prosecution, $150 public defender fee, and then, of course, he's been in jail for a while, so he would get credit for any time he served.
You have a score sheet there as well?
Yes, Your Honor, if I may approach. Are confused that there might be another charge out there of possession of a
Prescription drug. Whatever.
prescription drug,
It was all
but,
the same night. They just came back.
but I don't see anything else.
Clerk, do you have anything in this county on that?
He just wants to make sure he addresses
I
everything.
went to an initial appearance on it.
Apparently not, sir, at least in Okaloosa County. Apparently, there's nothing else, at least in Okaloosa County. All right, so, and do the inmates, can they hear my discussion that I had with the first person under the plea? All right. Sir, if you'll raise your right hand to be sworn, do you swear affirm the testimony you give will be the truth, whole truth, and nothing but the truth?
Yes, sir.
State your name, sir.
Schroeder?
And Mr. Schroeder, your attorney indicates you wish to plead nolo contendere to charges of possession of controlled substance, alprazolam, possession of less than 20 grams of marijuana, and possession of a drug paraphernalia, a container of some sort. And,
Your
I have a
Honor-
written plea agreement here.
Your Honor, I may not have had him sign that. If you could double check for me, please. Thank you, sorry. This is for the court costs. Yep. And I seem to recall seeing.
All right, sir. I do have that document now, and is there signature on the plea agreement? All right, counsel, did he have a chance to read it, or did you just explain everything to him?
Your Honor,
So you explained it in its entirety, went through all the critical factors?
I did go through the critical factors that pertain to drug charges, Your Honor, and his rights that he's given up regarding having a right to a jury trial.
So, sir, your attorney go over those issues with you? You understand you have the right to a jury trial on these charges? At that trial, the state would have to prove guilt beyond every reasonable doubt. You'd have the right to confront or question witnesses who might testify, the right to bring in your own witnesses by court order if they would not come in voluntarily, the right to present any defenses you may have, any legal challenges, or raise any legal challenges to any of these allegations. You'd have the right to either testify or stay silent, and you'd have the right to appeal if you were found guilty, along with after presenting any possible defenses. You understand that? Any questions about any of that?
No, sir.
Have you had enough time to talk to your attorney about that?
Yes, sir.
Are you satisfied with your advice? Has anyone promised anything other than what is in this agreement to get you to plead? Have you been threatened, forced, or made to plead when you don't want to? Any medicine, drugs, or alcohol in the last 24 hours? Have you ever been committed to a mental health facility? You understand that if you mess up and get a new charge in the future, you could be facing more serious consequences by having these charges on your record. And this, is there any driver's license involvement here?
No, Your Honor, because this is a withhold, but I did go ahead and explain to him that it could, if something were to ever change, that on a drug offense, that it does affect your license if you're adjudicated.
Well, with just a cost here, then that's not likely to occur, but there might be some administrative things with the Department of Motor Vehicles. At any rate, tell me what happened.
Alprazolam in it. I was walking to the store. An officer stopped me and she said it was a routine check. She said they had a complaint in the neighborhood. I asked for my name. I was very compliant with her. I let her know what I had. I literally forgot I had the Xanax. Just being honest, I was with a girl that night. She had asked me to hold the Xanax. I'm taking responsibility, though. It was my fault for holding them, you know, so I had been drinking that night, honest to God. And so I walked and left my truck at the house, and I walked to the store to get cigarettes. She stopped me, asked me for my name. I was compliant. I told her what I had in my sleeve in the container. I was smoking marijuana out of a socket. And
Well, the point is, why did you tell them about all this stuff? Yes.
I knew I had it, so I was gonna get searched. My name's not really great, you know what I'm saying? So I knew she was gonna at least search me, so I wanted to, no reason to lie to him, you know? I've had enough trouble with the law that I don't want no more trouble. But I had honestly forgot that I had that girl's Xanax in my bottle. I thought I just had the weed and that socket on me.
But you had agreed to hold it for her.
Yes, sir. I did agree to hold him to,
So
so.
find your plea on these matters to be freely, voluntarily, knowingly, and intelligently made. There is a sufficient factual basis to support the plea and waiving any PSI.
Yes, Your Honor.
All right. Any objection to the score sheet with 16.4 total sentence points?
No, Your Honor.
Right, sir, at this time, the court will withhold adjudication of guilt. You'll be required to pay $515 in court costs. You'll pay $100 cost of prosecution. You'll pay a $50 public defender application fee if unpaid, plus a $100 public defender fee, and you'll receive credit for time served. And how do you handle the payment of these? Just do a judgment in this matter, or? Sir, how long do you think you need to pay all these monies?
Your Honor, if you could give him at least 30 days.
Think you can do it within 30 days? All right. You pay it within 30 days from today's date, and if you fail to do so, you have to come in and set up a payment plan, or you have to come in the meantime. If you determine you can't pay it, go to the clerk's office before the 30 days is up, enter into a payment plan with them, and you'll avoid consequences. If you mess up, if you don't pay it off, or if you get into a payment plan and you default on the plan, then you could end up having your driver's license revoked for that process. You understand that? All right. You're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one will be appointed.
Thank you, Ms. Rivers. That's it.
Your Honor, Lisa Rivers for Richard Whitfield. He's before the court on 20 CF 2835, 20 CF 2859, 20 CF 2887, 21 CF 443, 21 CF 446. Your Honor, the state has conveyed an offer to me prior to court starting this morning. I haven't had an opportunity to discuss it with him. It wouldn't change anything if we tried to put it on a different day. So at this point, I'm going to enter a denial and request a new court date.
How long do you need to be prepared?
Your Honor, the 28th, February 28th would be fine.
Is there a separate time for contested hearings? And all these matters are similarly situated?
Yes, Your Honor.
Reset for February 28th.
That would be with no subpoenas.
I'm wondering why. I mean, if you don't settle it by some reason,
That would be the next court date that we could come to settle it. And I know the state usually prefers that you plea it out beforehand if it's not going to be contested, instead of having witnesses there that day.
it creates an issue for your client. I mean, he'd have to stay in jail longer if you aren't able to resolve it, potentially. I mean, he might have to anyway if he were found guilty, but that's a different question.
It wouldn't, in this particular circumstance, it won't affect him.
Whitfield, is all this acceptable to you? All right. And we'll be reset for the 28th. No subpoenas.
And I'll, to you.
Morning, Judge. Charles Russell, Public Defender's Office for David Weisar. This is Mr. Weisar present and approaching. We are here on case numbers 21 CF 1739 and 21 CF 1740. We are here because Mr. Weisar had filed a Nelson hearing request. It should show up in the clerk, I think filed like February 1st.
This says to all three cases, I believe it is.
Should be two cases,
Two
Judge.
cases, I believe.
39 and 40.
All right, sir, if you'll raise your right hand to be sworn. You swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God? All right. And state your name, sir. Weisar, you have public defender appointed, Mr. Russell, and under the circumstances, you filed your motion for a Nelson hearing. We're here to conduct that hearing today. You have the right to an attorney. If you can't afford one, will be appointed. One has been appointed. And you have the right, if he were falling below the standard of representation that is appropriate in the cases such as yours, to have him removed and have alternative counsel appointed, or to remove himself, which is a different issue under a forensic analysis. The point is, you have multiple offenses here. In case in 2-1-1739, you're charged with crimes against a person, harm to a public servant or family member, resisting an officer with violence, and narcotic equipment possession or use. Those are offenses, I believe each is a third-degree felony for the first two and a first-degree misdemeanor for the third charge. So you could face up to 11 years in prison or jail, 11 years probation, $11,000 fine, court costs, or other consequences. And in the other case, 21 CF 1740, you're charged as a sex offender failing to notify the sheriff of intent to move. I believe that may be a second-degree felony, where you could get up to 15 years in prison, 15 years probation, $10,000 fine, court costs, or other consequences, and you might face some sex offender consequences from that as well if you haven't already been subjected to them in the past for the charges that resulted in your obligation to register. And tell me specifically, sir, do you understand the nature of your serious charges? And I'm acquainted with Mr. Russell. I've known him for a long time. He is an experienced attorney. And so the point is, you certainly have the right to express your dissatisfaction. Could you identify or articulate that for me?
Second Nelson hearing since December. And I've requested for almost 2 years now a point sheet, a offer from the state. I've written the state. I've requested that my cell phone, the whole incident was recorded over a cell phone. My cell phone be got from the sheriff's office, and nothing is being done. Nothing's being done. I haven't even, there's points of my case or what I'm charged with, they can't even charge me with, and I'm trying to express what's going on. And I've had like 1, 2, 3 visits from Mr. Russell, and we're still doing depositions, you know what I mean? I'm ready to get this over with, and nothing is being done. He told me Ms. Bozzo refuses to give him a point sheet. That's what he told me, why I can't have a point sheet. Or Ms. Bozzo refuses to give me an offer. I've tried to make a counteroffer, and he won't give her the counteroffer because she hasn't made an offer. I just don't feel that Mr. Russell can represent me to the best of his ability with the caseloads he's got, or doesn't want to.
And counsel, has the defense been provided a copy of a score sheet or a plea offer?
Yes, Your Honor, and there might have been a bit of a mix-up because it did go through some different attorneys. Originally, it was provided to the original attorney, and then I did re-provide it to Mr. Russell as recently as yesterday, so he does have it.
So when did you receive it, Mr. Russell?
Judge, I looked at it this morning. She did email it to me yesterday afternoon. I printed it out this morning. I am right now providing a copy of the score sheet to Mr. Weisar. I will meet with him later and go over the plea offer with him. So that issue, I think, will be taken care of.
Sir, we've got it here certainly belatedly, but there is an issue apparently. When did you come on the case, Mr. Russell?
Probably April.
It's taken this long to get all that stuff over?
We've had depositions set, but some of the witnesses did not show up. We finally finished that. One of the witnesses is actually in an assisted living facility in Pensacola, placed there by Adult Protective Services with DCF. I recently had my investigator make contact with her. She is not, based on what I hear from my investigator, she is not going to be able to be deposed because she's not really competent to testify. And so we're not going to take that lady's deposition. And so for Mr. Weisar and the court's benefit, I anticipate that when this case comes in for pretrial conference on the 27th, that we will be ready on both cases for trial.
You addressed the issue about access to a cell phone, and have you had an opportunity to review that?
He brought that up recently with me, Judge, and we are in the process of looking into that. That was placed on hold once I got his Nelson hearing request, but if the court denies the Nelson hearing request, then we'll continue to look into that.
And Mr. Weisar, I do want to mention to you that typically a subpoena is an issue that's used for trial. Defense counsel has the right to discovery and to go to the jail and review evidence. It doesn't take a subpoena, although it might take a subpoena to get it to court, but typically the state would bring in evidence, although the defense could do it as well. So you've had a new revelation here today. You have been here a long time. It's going to take a while for a new attorney to handle the case if you were authorized one, but it sounds like Mr. Russell now has some things for him to take action on, and I'm wondering how that, has that altered your view of these matters at this point?
Oh, because I feel like the only reason why this was done is because I did file another Nelson hearing. That's the only reason why this got done.
He can't make the state do what they have not done, and you've heard the explanation that apparently was sent to other counsel. And was that with the public defender's office?
Yes, Your Honor. Like I said, there was some switching going back and forth. Everything's settled in, obviously, now.
Well, it is a little bit concerning because typically there's a single file. I'm not sure what your filing system is these days, but you would expect that anything received by one counsel would go on to subsequent counsel,
You would think, Judge.
but not so.
I checked my file as late as this morning. I could not find any paperwork, and I couldn't find anything in stack, and so that's why I had requested it again from Ms. Basso, and she has provided it to us.
Well, do you have any other complaints, Mr. Weisler?
Stated that I feel the public defender's office cannot represent me, or not even trying to represent me. I have to take, this is my second Nelson hearing, and I just now got this that I asked for almost 2 years ago.
Got you.
I feel like I'm being railroaded. That's why I feel like I'm being railroaded, that both parties are working against me, not defending me, but working against me. Both of them, my attorney. I feel there's no way that we can get along to even try to begin for him to represent me when I have no faith or trust in him at all. None.
Under the circumstances of him having just received the information, some of the information that you requested, and he's in the process of trying to analyze the evidence that you've identified, you'll have an opportunity to do that through normal discovery process of going to the jail and viewing the evidence. And under the circumstance, I'm going to deny your motion.
I represent myself.
But
I feel like
the point is, I can go through that analysis if you like. And the problem that you have is with you being in jail, well, it has been difficult for him to get some stuff. It'll be even harder for you to do the analysis of particularly getting access to the phone and being able to review that.
2 years, nothing's been done in 2 years. And I feel like you're sticking me with the same attorney that's not doing anything for me.
The point is, stuff has started to move. If this doesn't get resolved, I would be highly confident that the court would consider any future objections if these issues don't get addressed in a timely fashion. This is disconcerting. under the circumstances of when your arrest occurred, I'm sure that, as with so many of the cases in the court system, COVID had an impact on the ability to get certain things done. It is disturbing that apparently there was a failure to properly file documents that had allegedly been forwarded to the public defender's office, and but they are there now, and you have
I was
copies.
told from Mr. Russell that she refuses to give him a point sheet. That's what he told me.
You apparently got one now, as I understand it.
After I had to take the,
I got you. I understand that fully. The point is, it's there, so although it is belated, it's now there, and hopefully you can go forward. He is a capable attorney and will represent you to the very best visibility. But under the circumstances, you have mentioned the issue about a Feretta matter. Do you wish to represent yourself?
I wish for somebody that's going to represent me properly. Not just, I'm not a piece of trash that they can just do anything to.
I agree, sir.
And he's doing nothing. It took 2 Nelson hearings to get this far.
It has gotten this far, and things have started to move, and hopefully things will be moving quickly in the next 2 weeks, but the point remains the same. I've denied your request to have him removed, and under the circumstances, you'd mentioned the issue of a Feretta matter to represent yourself. You wish to go forward with that, or give him one more shot?
I wish for another attorney. That's what I wish for.
I've already denied that, sir.
I'm not going to see this attorney, so how can he represent me? When he calls me out, it's, the only reason why he's going to call me out is because this happened. It's not because he's doing his job for me. He's doing nothing to help me,
Seeing
nothing.
you between now and the time of this pretrial conference on February 28th, I anticipate that he will have looked at this evidence personally, and hopefully had an opportunity to get a copy of that, or download it, or review it, or take a video from it, and see, and show that to you. Do you think that's possible, Mr. Russell?
Yes, sir, I'll do the best I can between now and the 27th.
So I need you to do the very best you can and get this done.
Yes, sir.
Get this gentleman some effective representation, and be prepared to move this case forward.
Yes, sir.
So it'll be reset for the 28th.
27th, Judge.
The
Sorry.
27th.
Thank you, Judge.
Do I have the right to file another Nelson hearing?
You have the right to do whatever's legally permissible. Hopefully you'll see where it goes with him getting this information for you. Mr. Russell, if you could submit a proposed order. Mr. Russell, please submit a proposed order on his motion in Word to Ms. Hoke.
I can, Judge.
By you for signing.
And just basically saying Nelson hearing denied?
Right.
Okay.
On the merits. The hearing was conducted and the requested relief of substitution of counsel, removal of counsel and substitution of alternative counsel is denied.
Yes, sir. I'll take care of that, Judge.
All right, and who is next, please?
He was going to call, and I was further down the docket than him. All right, Judge, this is Daria Lewis. We have been trying to get her VOP resolved. The state and I came to an agreement on how to handle it, and she has agreed to it as well. But the question came up last time we were in court. Ultimately, we want to get her transferred up to Memphis, where she'd be living with her father in a more stable environment. The state's in agreement with us on that, but the question came up, where does she stay until then? We thought there might be a cousin available. I sent you an email about it. But what's the state's position on it?
Your Honor, on Ms. Lewis's case, she actually scores out to prison, but we're willing to give her a chance to undergo drug treatment, indicate, and live in a stable environment. Our concern is the stable environment. That is why we agreed to the request to transfer it out of state to live with a family member there. However, that request will take a while to work its way through the interstate compact if they'll accept her and all that. Releasing her pending that transfer to an environment that we do not believe would be stable would be a concern. So at this point, I don't think there's a place to release her to, so the state would object to that. The only thing that we feel comfortable with right now is the environment in Tennessee. Now, if you have more information that we can discuss, fine, but at this point,
the only information I would have would be, again, the boyfriend's parents, who I understand is a pastor, the father is a pastor.
that's maybe
Where do they
something
live?
we need to talk about with probation and parole, maybe, Your Honor, not with the court, because,
Judge, we've got cases this afternoon for
no,
arraignment.
I'm in court this afternoon with the trial, so sorry, I won't be here.
Could you and I talk about it this
Yes.
morning, and then,
Here's your other challenge, counsel. I mean, it's up to the receiving state to grant
Oh.
permission.
Right.
and that's why we got to find her someplace here, or is she going to stay in jail until that happens? They can't even process the paperwork until she is placed on supervision.
Has
So
she been in custody?
she's currently in custody, Joe.
How long has she been in custody this time?
This is a violation of probation, Your Honor. Like I said, she does score out presumptively to DOC, so,
She was another attorney's client when I came on board.
let's see.
Let me see if I can see when the rearrest date was. I've had her since the beginning of December.
Violation goes back to June of 2022.
June of '22.
And what's her recommended sentence if violated?
Judge, her guidelines put her at 107.8 total sentence points, so her lowest permissible would be 59.85, and that would be on the third-degree felony of failure to register.
So, ma'am, you've got an issue here that's particularly challenging about having a good place. You've had history, at least according to the allegations here, of some difficulty with some charges, and had an issue of interstate compact issues where another state would have to agree to accept you. And Florida can't make them do that if they don't want to have you there. So in the meantime, your charges are fairly serious, with serious consequences if you were found guilty of these violations. You understand that?
Yes, sir.
Judge, I should probably add, a condition of our plea agreement is that if Tennessee will not accept, she would return to the court for either a modification or withdrawal of the plea if we couldn't find an alternative. The whole idea is to get her living with her dad. We just got to figure out where she's going to be between now and then.
And I'm presuming that you're in effect asking for some sort of release pending that determination.
That's what I would do. What I was going to initially simply suggest is the state and I discuss it, see if we can come up with something,
Here's the problem you have, no matter what.
and then bring her back this afternoon.
Well, she can't do that because Ms. Bosso's not going to be here, but the point remains the same, no matter when you get through this process. She's going to have to resolve these charges, be sentenced, and then
Yes, sir.
have the transfer request done after sentencing.
Yes, sir.
I think as a part of a bond issue, I don't think they would do that. Typically, it's as a part of a consequence for someone convicted.
I have confirmed they cannot start the process until she's sentenced.
So until you get the ultimate issue resolved, how long do you need, counsel?
Judge, I have met with her twice in the course of this week, and have met with her, obviously, prior to that as well. Am now the second attorney. The only thing that we've come up with so far has been her boyfriend and her boyfriend's parents. We tried a cousin, but the cousin lives in a public housing project, and so there's federal statutory issue with her staying there.
The issue remains the same. I'm not here to litigate those
Next
questions.
court date.
I understand, Judge.
How much time do you need to try to get this question resolved one way or the other?
Ma'am, do you want to pass it out one more docket? It doesn't look like bringing you back today is going to work.
I have an address.
You do have an address? And who would you be living with?
Nicole.
Nicole who?
It's here in Crestview.
Okay, Nicole who?
Grant.
Okay. And what is the address?
See if you can investigate that,
255
Mr. Williams.
MacArthur Street.
Judge, when is our next miscellaneous day, or just our next day to be in court, where Ms. Bosaw might be present? February 20th? 28th? Do you think you could check on that address and see if that would be acceptable?
I'll be speaking with probation and parole. I look to them for guidance on a lot of that.
Okay,
So,
all right.
but let's do it, Your Honor, if we could do this on the 28th, if for some reason we resolve something sooner and we can get back before court, we'll do that out of deference to Ms. Lewis moving forward. But I think we need to make sure that she's going to the right place.
The only issue we have is the time, and with not having a regularly assigned judge, getting someone in for an early plea becomes challenging, but if that's the best we can do, then that's the best we can do.
And we're going to try to see if they can work all this out as quickly as possible. So reset for the 28th.
Thank you, Judge.
Your Honor, Charles Berry with state probation. If she will put on the record the address, we may can try to check on it for her.
She did. I don't know that she did it loud enough. So if you'd restate that address.
255 MacArthur Street.
255
MacArthur, like the general.
Crestview?
Say the number again, ma'am, make sure we're,
255 MacArthur Street.
And the person's name? Grant? Can I ask another question?
go ahead.
Any kids? Thank you, Your Honor.
So how long do you think you need to do that, sir?
How long will it take us to investigate it?
Yes, sir. Can you do that? Here's the question. Can you do that this morning before we complete our docket?
I can,
Okay, 28th.
I can reach out to someone at the office real quick, just to see what the guidance I can get, and I'll be glad to do that right now.
Well,
Can we pass her to the end of the docket then and see if we get an answer?
Give it a
If we
try.
don't, we don't. Thank you, Judge.
Thank you, Your Honor.
All right, we're going to pass you till the end of the docket and see if we get an answer by then.
please keep her here. Do not let her go back.
Judge, you want me to call?
Yes, sir.
Cases since I have the file. Everett Johnson. Mr. Johnson's in the courtroom, Judge. We have negotiated plea in Mr. Johnson's case. Make sure the state's signed it, yeah. If I can approach, and I also have a score sheet.
Sir. All right, sir, if you'll raise your right hand to be sworn. Do you swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, sir.
Everett Johnson.
Mr. Johnson, did you hear me explain the rights to others who entered a plea earlier this morning?
I did, sir.
All right. And is this your signature on the written plea agreement?
It is, sir.
Did you have a chance to read all of this before you signed it?
I did, sir.
And do you have any questions about anything in it?
I do not.
Do you understand everything in it?
Yes, sir, I do.
And it appears that this is a violation of probation or community control, is that right?
It's a violation of probation, Judge. It'll be amended to add community control. He'll have 6 months community control, and then we'll have to finish out his probation and has to complete all the requirements that he previously had.
This is based on the affidavit that was apparently filed
Yes, sir.
January 12th.
Yes, sir.
Sir, it appears that you're on probation for you count a possession of a controlled substance, and you have multiple allegations of violating your probation. You have a score sheet here with I do note that there was apparently on the score sheet a driving license canceled, suspended, or revoked.
Yes, sir.
But apparently that supervision has already expired.
I believe so, Judge. That would have been why I didn't include it.
So it's not on the affidavit either, so.
Oh,
But the point is, sir, it's alleged here that you failed to live and remain at liberty without violating any law by giving false ID to a law enforcement officer on January 11th of this year, and says that you were apparently charged by the Sheriff's Department with Officer Berry. Charged also with driving with your license suspended or revoked, a second offense on January 11th. And then the third allegation is that you committed an infraction or a violation of the law by attaching a license plate not assigned on that same arrest. Sir, for a violation of probation, the comments I made earlier are all the same with a couple of exceptions. Number one, you do not have the right to a jury trial. You only have the right to a contested hearing. Number two, the burden of proof is much lower. You only have to be found guilty by what's called the greater weight of the evidence. That's a much lower burden of proof. Otherwise, all the rights remain the same, except that you can be compelled to testify regarding technical matters versus criminal law violations. You understand that?
Yes, sir.
You still have the right to remain silent regarding any criminal law violations, presuming those criminal law violation charges have not yet been resolved. And have those charges been resolved at this point, counsel?
Judge, I do not know.
Have you gone to court, county court?
Yes, sir. I was in court 2 days ago, and my case was continued, and my attorney, Mr. Hall, told me to work progress toward getting my license. Therefore, the matter will be resolved. So as long as I continue to work toward the progress of getting my license.
For the purposes of this hearing only, is your client entering a plea of no contest as to all three allegations?
Judge, my normal practice and my preference is everything except outstanding new law charges.
That's my question, because he can enter a plea to those for the purposes of this hearing only, and I'll let him stipulate that there's a sufficient basis to violate his probation, which is not an agreement that he's guilty of any new criminal law violations.
And it would be no contest as well, Judge.
Is that acceptable to you and your client?
That is, Judge.
Is that acceptable to you, sir?
Yes, sir, it is.
All right, so I would normally go through and ask you all about what happened, why you got stopped, whether you gave false ID, whether you didn't have your license back yet, which kind of sounds like you might not. But at any rate, in addition to having a wrong plate assigned to the vehicle, I won't ask you about any of that stuff because those are criminal law violations. But by stipulating to the factual basis, you're agreeing that there's at least enough evidence to find you guilty of violating this probation. This cannot be used against you in that new case in county court. Do you understand that?
Yes, sir, I do.
All right, is that acceptable to you?
Yes, sir, it is.
And I'll find your stipulation and your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea. You're waiving your right to any legal issues or any defenses for the purposes of this violation of probation proceeding only. It's not waive any matters for the purposes of new criminal charges. And so I do find you guilty of violating your probation, and your probation will be revoked, and you'll be adjudicated guilty. You have a score sheet of 26.2 total sentence points. Any objection?
No objection.
All right, sir. I'm going to modify your probation to have 6 months of community control, followed by probation for the remainder of the term of probation originally imposed. All the original conditions are reimposed to the extent they have not yet been satisfied. you'll pay an additional $100 cost of prosecution. And do you need a hearing about a reasonable attorney fee?
Sir?
Do you need a hearing about a reasonable attorney fee?
I do not.
Public defender? And
I do not.
You're stipulating that you have an ability to pay?
Yes, sir.
All right. Then they'll find that you've waived your right to a reasonable attorney fee hearing. You'll pay a $50 public defender fee, application fee if unpaid, plus a $100 public defender fee.
Thank you, Judge.
And so that's on, the community control is on count one, or excuse me, on the, was apparently the remaining felony charge, so it's on that charge. The other charges are all moot at this point, as I understand it.
Thank you, Judge.
So you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
All right, thank you.
Thank you, sir.
Ethan, connect. Judge, this is a case where I had had communications with the state prior to January 5th. He had a new charge that he had not yet been arraigned on, and discussed with them. We had an offer on the other charges and discussed with them bringing the new charge in and making it part of that. I've got copies of that email chain, as well as copies of the plea agreement that was drafted that had this case number on it, and copies of the score sheet that had this case number on it, and I've highlighted all that. What we're here for today is the clerk was not showing that the 3113 case had been resolved. In looking at the Court Smart video, in my own defense, I will say this was my first day back after COVID. You can see me wearing my face mask on the video. I did not specifically say, Judge, I need to arraign him on 3113. And when the court announced the cases in the beginning, he didn't announce the 3113 case, and I believe that's where the disconnect came with the clerk's office. So here's the sum of my research on it, and the question is, for the court, we need to get him, sorry, I need to get in front of a mic. We need to get this case off the docket, folded in with the others. The court can either find that he did in fact enter a plea, or we can arraign him on 3113 this morning, re-enter the plea, and ask that he be sentenced to the same sentence, nunc pro tunc, to January 5th.
State's position.
Your Honor, Mr. Williams is referring to court proceedings that occurred on Ms. Leone's case. I believe the appropriate thing to do is get a copy of the court proceedings from that day. We can get a copy of the audio recording.
I have a copy of the Court Smart on it. I'll go ahead and just give it to you. I reviewed it. I sent, again, an email about the situation before, but Ms. Leone's been in trial.
Reset it for the next available, and if he can resolve it, we can resolve it off without another court date?
That's fine. Would the state and the court accept on the off chance that he can't be here for some reason, a written plea in absentia on it?
No, this is on a felony. I don't think that's permissible.
Okay.
Felony failure to appear, isn't it?
It is. The next date is going to be February 27th. Can you be in court on that date?
Yeah, if we can't get it done today, I guess.
Okay.
Sorry, would you be available that date, sir?
Yeah, if we can't get it done today, then I'll just have to.
We set it until the 27th. Let me return this to you, Mr. Williams.
Thank you, sir.
Is it 27th or 28th, ma'am?
27th.
Okay.
What time is it?
It'll be 9 o'clock.
Okay.
Yep.
Oh, thank you.
That's it. Okay. The next one that I have is Justin McCall. Mr. McCall's incarcerated. He'll either be in a wheelchair or using crutches. Judge, this morning, Mr. McCall is on the docket for 3 violation of probation cases, but he's also on the docket for this afternoon to be arraigned where the state combined several different burglary cases into one case. They null processed the old ones and direct filed under one case number. So what I'd like to do this morning is pass out his violation of probation case to a later date. The sole reasons for violation, if I recall correctly, are the new law violations, and then go ahead and arraign him this morning on the 23 CF 48 case, so that, frankly, so he can go ahead and be transported back to the jail where he'll be more comfortable. He suffered a gunshot wound to the left leg, I believe, and with some resultant bone damage, and so that's a somewhat more painful situation.
I can see here that the original VOP affidavit included an October 29 incident of burglary, apparently, of some conveyances, and then we got the new charge from January 3rd or 4th, burglary and petty theft. Along with, that was the first amended stuff, and then there's second amended charges, once again, more from January 3rd and 4th. So that stands now.
No, Judge, I'm certainly not looking at the information that was filed. I don't see...
The second amended VOP affidavit, there are now 22 allegations of violations, so.
I don't see the October incidents as any of the counts in that one, Judge, but nevertheless, I would not be prepared to proceed.
I was just stating that for the record for your client's information. Apparently, they've entered a second amended affidavit of violation, so you wish to continue the VOP, but arraign him so that he can get back to the jail as quickly as possible.
That's correct, Judge.
All right. And what are the charges that have been filed on the new case? It's 2348.
Judge, he's got a grand theft of $750 or more, but less than $5,000. I believe that's a third-degree felony. Hang on just one second. Burglary of an unoccupied conveyance. Make sure I'm on the right one.
I can read them if you like.
Yeah, that's a third degree. Also, there's another, a possession of a firearm by a convicted felon. It's alleged that that's the weapon that he had that discharged into his leg. Right now, she's got that as a 1020 life. I'm not sure that the 20 is going to be appropriate since the discharge was accidental and was into himself. But I'll look into that. There's a criminal mischief greater than 200 but less than 1,000, so that's going to be a, it looks like she's got that.
Fairly encompasses a number of prior cases. And as I understand it, contains 11 counts.
That's correct, Your Honor.
Yes, sir.
So he's waiving a reading of the amended information and pleading not guilty to all allegations. Is that
That's correct, Judge.
Have you been appointed on this case already?
I believe so, Judge.
Has Speedy been appointed on this 23 case? Yes.
Demand trial by jury and request 15 days for any pre-arraignment motions.
Was granted. So, Paul, we've got a number of matters here. It's a serious nature. Looks like you apparently are doing better with your recovery. I'm glad to see that. I would expected to see you in a wheelchair coming out, from what I was told, but I'm glad you're moving around. Hope you're recovering well.
Thank you.
All right. And how do we want to schedule the jury trial? Okay. How do you want to proceed, counsel?
Judge, I spoke with him last night, and the date that we had discussed was February 27th. I advised him it might be a later date, but for now...
Will you be ready by the 27th?
I have already reviewed all the discovery that's been provided on the original set of cases. There may be some additional discovery that's provided, and if that happens, I'll move for a continuance at that date. But I know that he's anxious to try to figure out what's going to happen and perhaps get it resolved as soon as possible. So at this point, I'm not going to ask for a later date.
You understand that, sir?
Yes, sir.
That's acceptable to you at this
Yes,
point?
sir.
Your attorney will tell you how things are progressing, and you can make a decision if the state makes an offer. And go from there. Has the state filed notice of intent to seek any enhanced sanctions?
Not at this time, Your Honor.
But there is a potential 10-20 life issue here.
Yes, Your Honor.
One of the charges.
Yes, Your Honor.
All right. And so you've heard Mr. Williams' comment about the alleged accidental discharge.
I did, Your
Whether
Honor.
that affects that decision or not.
I did, Your Honor.
Okay.
You can provide me any documentation or case law to support that, and I'd be glad to.
It's a case of first impression for me, Judge, so it'll take some research.
It will be a rather novel question, because
That one doesn't usually come up.
we already said it. What do you want to do with the VOP? Set it for the same date, just for,
We can set it to track for the same date. I imagine if we resolve anything, it'll be all of them.
Yes, Your Honor.
it'll all be reset then for February 27th, was it?
Yes, sir, February 27th.
All right, sir, your attorney will be in touch.
Thank you, Mr. Williams.
Okay, no problem, Mr. McCall. Take care and get well. Judge. I have Kenny. I believe handled everyone that I have that is not incarcerated. Judge, Mr. McKinney is going to be a negotiated plea, and I have a signed plea agreement signed by all parties. I don't think I've gotten another copy of the score sheet, though. Do you have a?
The substantive charges or a VOP?
Your Honor, this is on a VOP, and I would apologize to the court. It is his second violation of probation. I don't have the updated score sheet, but for the record, I can indicate that the updated score sheet will reflect 59 sentencing points, a maximum of 20 years. And I will get that to Madam Clerk.
If I recall, what I did, and I can look at this and tell you, is when I met with him at the jail, I took the score sheet from his previous case. In fact, I'm looking at it now, and actually, his previous attorney had already marked it for me. And we're coming up with 59 points as well, with lowest permissible of 23.25, and that's what I went over with him at the jail. I basically just added the additional points myself.
It's based on the amended affidavit from June 16 of last year.
Judge, let me look and see the date on it, but I do
That's
have
correct, Your Honor.
the amended affidavit. June 16th of 22, that's correct, Judge. Judge, if the court and Ms. Bosaw will accept the handwritten changes to the previous score sheet, as a score sheet in this case, I can go ahead and tender that and then print a copy out off the clerk's website for the file later.
No objection from the state. As long as the number is correct, that's not a problem. And if the court has no objection.
It's actually
That
gonna
fits with
suggest
what you
just
have.
and
That's fine.
correcting it and doing it that way. unless
Right,
the clerk
thank
has
you.
a problem with that.
Mine has all the e-filing stuff on it, so I couldn't do it. Okay.
Basically, the intent of this, Judge, is he's been accepted at an inpatient drug rehabilitation facility called The Farm, and we're trying to get him there. Where he messes up tends to be related to his drug use.
Sir, if you'll raise your right hand to be sworn, please. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name, sir.
Zachary McKinney.
And Mr. McKinney, I have a written plea agreement regarding your violation of probation here, and we've actually got a duplicate copy of it here, counsel. Sir, is this your signature on that agreement? And did you have a chance to read all of this before you signed it?
Your Honor.
Do you have any questions about anything in it? Do you understand everything in it? Do you understand that you're giving up your right to a violation hearing in these charges, all of your violation hearing rights that are listed in this agreement, and the right to appeal guilt? Now, at your VOP, the state would have to prove guilt by the greater weight of the evidence, bring in the witnesses before you, where you could question them or have your attorney question them, bring in your own witnesses if you had any, present any defenses or legal challenges you might have, and you have the right to either testify or stay silent on any new criminal law violations, although you might have to testify regarding any technical issues. You understand that? And those are all the rights you're giving up.
Your Honor.
And have you had enough time to talk to your attorney about your decision? Are you satisfied with the advice given?
Sure.
And has anyone promised you anything other than what's stated in this agreement? And I understand apparently you're going to get suspended sentence of 5 years in state prison, be restored to probation. That's a mitigated sentence, because otherwise you'd be facing a minimum of about 2 years in prison, according to this score sheet. But here's the problem. With a suspended sentence, if you come back for a violation of the probation you're going to be restored to, you could be facing that 5-year sentence instead of a much lesser sentence under the score sheet, at least as a minimum. Of course, it's totally in the discretion of the judge, if you violate probation, whether to give you the minimum recommended sentence, a higher sentence up to the legal maximum, or even mitigate the sentence on some other matters that are not normally recognized and give you a lesser sentence. You understand that? Any questions about any of that? All right. And have you been threatened, forced, or made to plead when you don't want to? Had any medicine, drugs, or alcohol in the last 24 hours? Ever been committed to a mental health facility? The first allegation, let me get back here. Got a number of allegations on the first page, all about failure to pay money, including your 4% surcharge, $61.41, failing to make restitution, saying that you were $382 behind, and failing to pay court costs that totaled $1,239.15. And did you have an ability to pay those monies while you were on probation?
Your Honor, but I have paid the restitution since then.
Okay, good. And why was it that you weren't able to pay?
I didn't have any job or money.
All right. You understand you may have a defense to those allegations of inability to pay that you give up by entering this plea. All right, you think that's best?
I do.
The next allegation says you changed your residence without the consent of your probation officer on May 16 of last year. You left your residence at 112 Bataan Avenue in Panama City, and they didn't know where you were. In conjunction with that, it said that you later failed to report at least one time a week, starting on instructed on May 16th to report at 12 p.m. Actually, you were instructed on May 10th to report on May 16th at 12 o'clock, but you didn't do so. And failed to remain confined at your approved residence. They checked on your dad's residence on May 18th at 8:15 in the morning, and you were not there. And failed to submit your hourly accounting of your activities in a daily log to your community control officer as you were instructed to do on May 16th. So it's all about leaving that residence and failing to do obligations relating to your supervision. What happened?
I had got into it with my father, that was the owner, and it seemed the lesser of the two evils to vacate that premises.
That may have been a very wise choice, but did you report that to your probation officer in a timely fashion, like the day it happened?
No, Your Honor.
You should have. It's easily done. Those kinds of things are fairly common, but they can be accommodated by probation. And I have another allegation here. It says you failed to remain at liberty without violating any law. It says on May 9th, you were in possession of a drug or narcotic. It was apparently some fentanyl from a needle that was gathered from a needle after you'd been found unresponsive. So
Judge, with regard to that one, if we had had contested hearings on it, I would have raised defenses of inability to pay, including the one where he didn't call or didn't get consent based on financial issues. On this final one, I would have moved to dismiss based on 893.21, which essentially creates an immunity for incidents revolving drug overdose. The idea is to eliminate any legal impediments to providing emergency treatment, including Narcan or naloxone.
well, this is for a violation of probation. It's not to the substantive charge itself. So is he pleading to it or not?
He's going to go ahead and plead to it, Judge. There's no point in disagreeing it since he's pleading to other substantive allegations.
Well, sir, sounds like you apparently may have had an overdose with a potential near-death experience. A lot of people don't make it past that. You're lucky to be here. That stuff is a scourge on the community right now. And the problem is, if you have no way of knowing whether you're getting a hot shot or not. And if you do, you can die if somebody doesn't respond quickly and provide appropriate care. How long have you been using?
Off and on for probably 10 years.
And any treatment before?
Not long enough ones, just short term. Just wasn't what I needed.
Point is, no matter how long the treatment may be, they typically all give you the same information about how to get into committed and hopefully effective recovery. The burden is then on you to use the tools you're given in a responsible, committed way. That means you got to change the people, places, and circumstances of your life, the places you go, the people you see, the things you do. Because as you well know, anything can be a trigger to use. And with the stuff you've been experimenting with or using, you're on a very dangerous track, and that's got to stop. He's a very pleasant young man in this circumstance, and it would be a shame if you ended your life accidentally by doing that foolishness. I encourage you to think about it.
Yes, Your Honor.
Is getting high worth your life? Absolutely not. All right. At any rate, so under the circumstances, I won't inquire about it, but he's admitting the violation, so.
Yes, sir.
Objection to the score sheet with 47 total sentence points.
No, Judge, as I explained to the court, I checked the calculations and added those additional points when I discussed it with him, as well as any potential defenses that he had on the BOP.
Your Honor, actually, that was 59 total sentence.
Yeah, it's 59, Judge, if you'll.
Court said 47.
Sorry, I was looking at the front page. It is 59. It's been corrected on the second page.
Yeah, with the two
My mistake.
no felony concurrent sentencing violations, that's a total of 12 points.
All right. So at this time, sir, I do find you guilty of violating your probation. Your probation be revoked. You'll be sentenced to 5 years in a state prison. However, that sentence is suspended on the condition that you complete 5 years of probation. You'll get credit for any period of probation that you served up until the filing of your original affidavit of violation of probation, or the warrant that was issued from that filing of that affidavit. Probation, understand that?
I did not. I was going to stand up and ask
He gets credit up until the time the judge signed the warrant for this violation of probation, their first warrant, because there's apparently been an amended warrants filed for the VOP. You understand that?
So basically, it's told once the judge signs the warrant, and then now he's back on.
So we're just reinstating it.
I'm sorry, I need to correct that statement. Thank you for reminding me.
Yeah, we're good with reinstating.
Yeah, that's what we're
I mean,
doing.
he's
It'll be
on until 30.
Was it a 5-year probation originally?
Yes, Your Honor, it was.
So it'd be reinstated with tolling for the period of time since the filing of the first warrant for violation of probation for this series of violations.
Because he's on till April of 2031, anyway.
Well, it's 5 years here by this agreement, as I understand it. Is there another case he's on probation for? Because 5 years won't get to 2031.
No, it was 10 years total originally, so it's a reinstatement. You have the correct date.
But I mean, they told it, they just reinstated, he's on probation till
Yep.
2031.
We're good.
It's 5 years DOC suspended sentence.
Well, I've got this document before me that says it's 5 years suspended and restored to 5 years probation. Is that the agreement or not?
Judge, that's what he's agreed to. That's what I understood the offer was.
That's sufficient. Well, the state will honor that, Your Honor.
And it's a provision that he can seek early term at 36 if he
Yes,
gets
Your Honor.
everything done.
Good. We'll just start it today.
Do you agree that it says restore, but do you agree that under these circumstances, the intent was effectively to have that start today?
Yes, sir. Do you
New
agree with
5-year
that?
term then. I guess it works out to, right?
So to clarify, exactly.
Yes, please. Thank you.
So it
Thank you,
is
Judge. That
wrong.
works for us.
The sentence that I announced of 5 years state prison suspended and 5 years probation starting today. It'll be with all the terms originally imposed in the prior probation reinstated to the extent they have not yet been satisfied. There'll be an added condition that she'll enter into and complete a residential drug treatment program at the farm. Does he have to remain in custody until that he's admitted to that program?
That would be the state's intent, Your Honor. Bars to bed.
Judge, we discussed that with him, and he knows they're going to have to come pick him up.
Okay, so he'll remain in custody until picked up by the representatives of the farm. He'll successfully complete that program as well as any aftercare. He'll not possess or consume any alcohol or controlled substances without a doctor's prescription. That includes any marijuana. And is it the intent not to use marijuana even if he were to get a prescription?
That's the state's intent, Your Honor, because it leads to bad decisions. By a
So
case.
There's a prohibition of this probation, even though with a prescription, medical marijuana is otherwise authorized in Florida as a part of this probation. That does not apply to you, sir. You can't get medical marijuana. You understand that?
Okay.
Or once the probation is up, you'd then be eligible to, if you got a prescription, to do whatever's permitted by law.
Judge, we're going to go ahead and accept that. If something comes up where marijuana becomes medically necessary for some reason, we'll seek a modification. It's a term of probation, so we can move to modify it anytime.
Sir, you'll submit to random breath and urine testing. You'll pay a $100 cost prosecution fee. And do you need a hearing about a reasonable attorney fee with a $50 application fee of a $100 public defender fee? Shaking your head no, so I'll find you've waived your right to a reasonable attorney fee hearing. And you can seek early termination at 36 months if there are no violations and you've satisfied all the conditions of this probation. That includes the payment of the original costs and restitution and everything else. All right. So, is there anything over?
Not from the state, Your Honor. Thank you.
Nothing I'm aware of, Judge.
Okay. Sir, your advisory right to appeal within 30 days. You have the right to an attorney. If you cannot afford one will be appointed. Good luck to you, sir. Stop using, get into treatment, get into recovery, make it an obligation to yourself and your life.
Your Honor, thank you.
All right, good luck to you. You guys need to talk with him? Yeah, come, go have a seat over there. Judge, the next one I have is,
They want to do the in-custody folks first, if that's permissible.
this gentleman is in custody, Marshall Nance.
Your Honor, can I inquire where the farm is?
Yeah, you sure can. I've got another copy of this that I received.
While he's looking for that, Your Honor, due to the fact that he's going to be in the farm and the fact that he has been determined to be indigent by the appointment of the public defender, we request the supervision fees be waived.
Supervision are waived.
Judge, if there's any other attorneys, we may want to go ahead and let them call the case while I provide this information to probation.
Junior, I think Nancy's on there.
Nancy, oh, I'm sorry.
That's all right.
Then we don't need to. Judge, do we have a Moran?
We're getting Mr. Vance out, as I understand it.
No, this is.
No, it would have been Nance, Judge, with an N.
Sorry.
November Alpha. Is that yours?
No, this is Mr. Barnum.
Barnum, okay. Let me just get out of your way.
Last name again, please.
This is Mr. Camden Barnum, Your Honor. Tim Gibbs on his behalf, 22 CF 3192. Your Honor, we're here for a motion to set bond in Mr. Barnum's case. At his first appearance, Judge, he was given a first appearance on a charge of second-degree murder. The court at that time did not set a bond and ordered the state attorney's office to file a pretrial detention motion. There was not a hearing on that motion specifically, however, the motion was filed. Judge, he is entitled to a bond considering that it is not a capital crime. He is requesting a $50,000 cash professional bond that he believes he would be able to furnish. We certainly have no objection to any pretrial supervision and any other reasonable terms that the court may want to impose, such as surrendering any passport. I don't believe he has a passport. That he be placed on GPS and not possess or use firearms except through his employment. He is a staff sergeant in the Army. He has been with the Army since 2012. Currently, I believe, is an E6 in rank and was working his way towards becoming an E7. He has lived in this area only for about 18 months, Judge. He does have some family in Hillsborough County. I do have, I believe, I had filed a motion for his aunt, Kashanta Nunn, to testify via Zoom. I don't know if that order had been filed approving her testimony via Zoom. I would just raise that motion as well for her to testify. But he would be living locally here. Otherwise, he could either, I believe he's got three options. He could live at the house, which they are, I believe, preparing to sell. He could be remanded to the base, which I believe is at Duke Field, or he could live with his aunt in Hillsborough. She has made that available as well.
What's his status in the military?
I'm sorry, Your Honor?
What is his status in the military?
I'm not sure as far as if they're going to try to discharge him. As far as we know, he's
Judge.
still there.
They are working very diligently at trying to remove him from the military as fast as they can. They have already done evaluations at the jail with Mr. Barnum. They are working very hard to separate him immediately.
What happened about scheduling the motion for pretrial detention?
I'm not sure, Judge.
I don't think that was ever scheduled.
No, Judge. I don't think it was ever set for a date.
Well, we have one was noticed for today as a motion for bond reduction. I did have an inquiry yesterday, and I asked, and I understood that there was going to be an inquiry to see if the state had any objection to the Zoom hearing. I didn't hear anything back, so.
I'm sorry, I'm not sure that came to my email, but I had no objection to it. It should have been in the motion that I didn't oppose the Zoom hearing. I'd rather Mr. Gibbs and Mr. Barnum have the opportunity to make the record as clear as they would like.
Well, since I didn't get any word back, I made no inquiries to try to get that coordinated. Can we pass the case until this afternoon at a time certain to see about getting all that worked out?
Ms. Nunn does have, we did send her the meeting ID number for this division for her to be able to log in. I believe she's in the waiting room now. I don't know if Your Honor has any of that pulled up, and I understand if the court doesn't. For her testimony, I wouldn't necessarily have an objection for her to reset this for this afternoon at a time certain to ensure that all parties are available to make their record clear.
Well, I've just recently had my computer information, oh, here it is, there is a Zoom setting here, so let's see what's what here. Maybe I can set it up. Okay, can you give me the, who is the,
The witness's name is Kashanta Nunn, Judge.
I need the sign-in information.
Oh, for the Zoom, for the account?
I'm not in this county regularly, so what's your understanding of how I need to set it up?
I'm normally, that's either done by the IT or sometimes the bailiffs. I don't know exactly who handles that beyond court administration. I wouldn't necessarily be able to give you that information. I don't have that. IT? Okay.
Okay, I'm using my court email address. Give me the password that you have.
I don't have a password, Judge. We can contact IT. Typically, how we have run Zoom in the past is the division has its own account that is logged into.
Senior judge sitting in, so that's kind of a hybrid, and that's
Correct.
the problem. If I'd heard back yesterday, I could have had all this taken care of.
Understood.
So, can you call Ms. Hoke and ask her to get a hold of IT to set up Zoom hearing for me and give me the information, have it set up. Let's make it 11:45. We'll pass the case until 11:45, see if we can get it set up.
That's fine, Your Honor.
I'll need all my login information for a Zoom meeting. Oh. Mr. Barnum will have that hearing at 11:45.
Thank you, Your Honor.
Right, next matter. Another case ready, counsel?
Judge, I believe I have another inmate waiting. This is going to be, Judge, this is going to be Nolan Cheshire, 23 CF 54, 22 CF 1321. Judge, I believe that 2023 case is also set for this afternoon. However, Judge, we have reached an agreement with the state in this case. If I can grab the correct written plea agreement.
Okay, what's the other case number?
So those two case numbers, Judge, are 22 CF 1321 and 23 CF 54. We've reached an agreement with the state in both of these cases, if I may approach with a written plea.
Okay.
Mr. Gibbs, do you have a score sheet on that, sir?
You won't have to come back. Yeah, we'll take care of both of them today, this morning. Yeah, you won't have to come back this afternoon. Okay, thanks. No, I did not. I'm sorry.
That was both cases, you said, correct?
It should cover it.
So,
That's fine. Thanks.
Your Honor, may I approach with the score sheet?
No objection to the score sheet, Judge.
Not a problem. Thank you. All right, sir, if you'll raise your right hand to be sworn. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, sir, please speak up loud and clear. State your name.
Nolan Chesser.
Mr. Chesser, I have a written plea agreement. It indicates that you're pleading apparently no contest to a violation of probation in case 22 CF 1321, and pleading no contest to new charges in case 23 CF 54. Those charges involving, for the VOP, are driving license suspended or revoked as a felony, possession of controlled substance, and then you have a new possession of controlled substance charge for methamphetamine, and driving a license suspended or revoked for a third offense in the new case. And I have that written plea agreement here. Is this your signature on the agreement?
Yes, sir.
Did you have a chance to read all this document before you signed it?
Yes, sir.
Do you have any questions about anything in it?
No, sir.
Do you understand everything in it?
Yes, sir.
You understand that you're giving up your right to a violation hearing on the VOP?
Yes, sir.
You understand you're giving up your right to a jury trial and all of your trial rights?
Yes,
on
sir.
the new charges?
Yes, sir.
And in those matters, the burden of proof for the VOP is only proof of guilt by the greater weight of the evidence at a hearing on whether you violated. That's not a jury trial. But on the new case, you'd have the right to a jury trial with a higher burden of proof of guilt beyond every reasonable doubt. You understand that?
Yes, sir.
And then you're giving up all of your other hearing rights or trial rights. They include the right to confront or question any witnesses who may testify, the right to bring in your own witnesses by court order if they will not come in voluntarily, the right to present any defenses or legal challenges you may have, and the right to either testify or stay silent as to any new criminal law violations. You understand that?
Yes, sir.
On the VOP, you could be compelled to testify if there are any technical violations, but not as to any new criminal law violations. You understand all that?
Sir.
And have you had enough time to talk to your attorney?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
Have you been promised anything other than what is in this plea agreement to get you to plead?
No, sir.
Have you been threatened or made to plead when you don't want to?
No, sir.
Have you had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Have you ever been committed to a mental health facility?
No, sir.
The new case alleges that on January 6th of this year that you were in possession of methamphetamine, and the second count alleges that you were, having previously been convicted of knowingly driving a vehicle while your license was suspended, canceled, or revoked, apparently on two prior occasions in 2015 and in 2021. You drove while your driver's license or driving privileges had been canceled, suspended, or revoked on the highways of the state of Florida, knowing of the cancellation, suspension, or revocation. What happened? Were you driving?
Yes, sir.
Did you have at least two prior revocations?
Sir.
Why were you driving on January 6th?
I had been working on the vehicle for my cousin, and
You took it out for a test drive?
yes, sir.
So there wasn't some dire medical emergency?
Sir.
Can't do that until you get your driver's license reinstated. You understand that?
Yes, sir.
Why did they stop you?
I guess I was speeding. The speedometer was apparently wrong, but
Is that what they told you?
Yeah.
Stopped you for?
yes.
All right. Do you think that's true, that you were speeding?
Yeah. Yes, sir.
And tell me about how they found the methamphetamine.
It was in a boot in the truck.
Your boot?
No, sir, not my boot.
Your drugs?
No, sir, but
Did you even know it was there?
no, I didn't know it, but
You may have a defense to that charge if you were driving someone else's vehicle and this was stuff you never knew about, that you never exercised any control over. You may have a defense on the methamphetamine charge. You understand that?
yes, sir, but I need to be out, and
No, that's a choice you get to make, sir. The point is, I want to make sure you understand that you're giving up a possible defense to a charge that will increase your points.
yes, sir.
If you mess up on the supervision you're being offered, or whatever the sentence here is, then you won't be heard to complain about it. Judge, it should be a lesser sentence because I really didn't do one of those charges. That's gone after today.
Okay, yes, sir.
Understand that?
Yes, sir.
But you still want to go ahead and take this plea agreement, waiving any defense on that meth charge.
Yes, sir.
Go back and double check your VOP to see if there was anything else there. Like, they also said that apparently, at least for the VOP purposes, it wasn't charged in the new information. But for the VOP, they alleged that there was some drug paraphernalia too when you got stopped. You know what that was about? Was it a baggie or a pipe or something? Or do you know?
I don't know. No, sir.
Well, for the VOP, you'd be waiving any defense to that charge as well. You understand that?
Okay, yes, sir.
That's the way you wish to proceed, by waiving a defense to that allegation.
Sir.
It'll find your plea to be freely, voluntarily, knowingly, and intelligently made. There is a sufficient factual basis to support the plea. Any possible defense to the allegations 1 and 2 of the violation of probation or count 1 of the information are voluntarily waived. And any objection to the score sheet with 34 total sentence points?
No objection, Judge.
And, sir, at this time, I'll find you guilty of violating your probation. Your probation will be modified. You'll be placed on the next 12 months on drug offender probation, followed by 24 months standard probation. You'll pay a $100 cost prosecution fee for the VOP, and you have the right to a hearing regarding attorney's fees on these matters. Do you need a hearing about reasonable attorney fees?
No, sir.
Okay. I'll find that you waived your right to a hearing on that matter. You'll pay a $50 public defender application fee plus a $100 public defender fee on the VOP. You'll complete all the original conditions of your supervision to the extent they have not yet been satisfied. You'll have a curfew of 7 p.m. to 7 a.m. each day of the week, unless, which may be modified as deemed appropriate by the department for work or other responsibilities.
Sir.
You'll submit to a substance abuse evaluation within 30 days. You'll attend and successfully complete any treatment that may be recommended. You'll start that within 60 days of the recommendation. You'll attend, how many meetings a week are you contemplating here, counsel?
I believe it was one meeting per week.
You'll attend an AA or NA meeting each week for the first 6 months you're on supervision. And while I'm not ordering it, because it's not part of this, I'd recommend you continue it after that if you've got a drug problem. You understand that?
Yes, sir.
On the new case, you'll likewise have a 12-month drug offender probation followed by 24 months of standard probation. It'll be concurrent with the 22 case. You'll pay $515 in court costs plus a $100 cost prosecution fee plus a $100 public defender fee and all those monies will be paid within the first 34 months of your supervision. Are there any other requirements here I may have overlooked?
I don't believe so, Judge. We would request to waive his supervision fees considering he has been found indigent.
Granted. And, sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Sir.
Do you have any other questions?
Nope, I know where to do it.
All right, good luck.
Good luck, sir.
And, Your Honor, based on, okay, I'm sorry.
Thank you, Mr.
Counsel just did it for you.
I'll have another question, I'm sorry.
Your Honor, he doesn't have enough time on that original probation, so if the department can speak up and say, if we just revoke him and start him anew, then everything kind of travels together.
The terms on the written plea, Mr. Berry, state that his original probation is modified and extended as appropriate to fit this.
Okay, fair enough.
It was modified to extend it for that specific amount of time.
Thank you, Mr. Barrett.
As opposed to being reinstated and extended.
Thank you, Judge.
And that starts today. All right.
Thank you.
You need
him?
All right, anyone else? Anybody custody?
I don't have any out of custody this morning, Your Honor, so I'm just going down my jail list. Now, Your Honor, I have Mr. Kip Fee, Tim Gibbs on his behalf, 21 CF 189, 21 CF 1475, if I can have just one moment. Your Honor, we have not reached an agreement with the state. He was actually set to observe mental health court yesterday. Mental health court had actually shifted him over to drug court. I believe these are the only 2 felony cases he has in his history, and they both involve possession of controlled substance. However, Mr. Fee indicates that he wants to enter an admission to these violations of probation today and proceed to sentencing today. I have advised him that my recommendation would be that I still try to negotiate with the state to find a resolution. But it is his, of course, it is his choice to plea, and I wanted to make the court aware of that.
What's the score sheet say?
Your Honor, I don't currently have a score sheet, considering that his prior history consists of misdemeanors and that he only has these 2 possessions of controlled substance as far as felonies are concerned. This is also his second violation, I believe, on at least one of these case numbers. I do not believe that he would score a presumptive prison sentence, and therefore the court would have full discretion in sentencing him.
Your Honor, these are Miss Leone's case, who's in trial. I'm not sure if she has an accurate score sheet, but I have no objection to the defendant entering an admission and pleading today. I would just ask the court set off sentencing so Miss Leone can make a sentencing presentation if she chooses.
Talk to your attorney, sir.
Your Honor, I understand Ms. Glisson's request and respect that. Mr. Fee is very adamant he wants to try to sentence today. That is, of course, up to the court. We can set it off for another date if the court feels that's more appropriate. However, we are requesting to proceed to sentencing today.
Sir, my mental health is getting worse. I suffer from psychosis.
We'll hear what we have to say, and I'll make a decision after I've heard the presentations. I'm not guaranteeing that it'll be continued or not. So how does he wish to proceed?
Judge, he does at least want to enter an admission this morning.
Do you have anything in writing, or do you wish to do it?
No, this was a decision that was made today.
I have it in writing.
You will raise your right hand to be sworn. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
State your name, sir.
Kip Carlson, Fee the Third.
You're here for a violation of probation. You put your hand down, sir.
Yes, sir.
At the hearing, the state would have to prove guilt by the greater weight of the evidence, and he's entering a no contest plea to these violations. Is that correct?
I would like to enter a plea of guilty and see if it can be resolved today in hopes of reinstatement of probation. My mother's heart's working at 4%.
I was asking your attorney, sir, but thank you for that input.
It does appear I would like to tender a no contest plea or an admission to the VOP, Judge. I believe there is a factual basis based on the allegations and the violation of probation, and he wants to enter an admission to those this morning.
You indicated his willingness to enter and desire to enter a guilty plea. Which do you want to do, sir? Your attorney's got his recommendation. You're saying what you wanted to do. What's your choice?
In hopes of reinstatement of my probation,
Yes, sir. We're talking about the plea that you're entering. Is it guilty or no contest?
it would be,
Usually a good idea to take your attorney's advice.
All we're talking about right now is entering a plea to the violations of probation. So if you want to enter a plea, he's got to make sure that you understand that you're entering a plea, and later we'll proceed to sentencing.
I'm going to enter a plea of guilty today.
All right. And, sir, at violation, by the way, do we have a score sheet ready for presentation?
We do not have a score sheet present at the moment, Judge. As I stated earlier, I don't believe that he would score presumptive prison considering the history that I'm able to see as far as Okaloosa County is concerned.
Minister just said that it was 31.
34 points?
Yes.
Okay. If he last scored 34 points, Judge, then I don't believe he would score a presumptive prison sentence.
Can you locate, ladies, when the original score sheet was filed? In this case. Anyway, sir, your score puts you in a category of, if it's 36 or 34, the last time you were here, presuming that to be accurate, where you'd probably score 40 points for this violation. You'd still be under the amount for a recommended state prison sentence, but the court could send you to state prison if it felt it that appropriate. And the recommended sentence would be somewhere in the neighborhood of about 18 months or so, I would suspect, or less. And, pardon?
Gotten to that point yet. He's just letting you know what the
Just giving
possibilities
you
are.
some general information about your decision.
That they could recommend a suspended
Yeah,
sentence?
the state will recommend whatever they think is appropriate. The judge will hear our recommendation, and then the judge will make a decision. He's not ordered that we're going to a sentencing hearing today, for sure. He's just saying, he's letting you know what the possibilities are.
Point is this, sir, regardless of what the criminal punishment code says, then it'll be up to the judge to determine an appropriate sentence. It could be a higher sentence than what's recommended. It could be a lower sentence if you presented recognized mitigation that the court found persuasive. That'll be at the end of the hearing or at another date, depending on what I determine from this proceeding. At your violation hearing, they'd have to prove guilt by the greater weight of the evidence. You'd have the right to confront witnesses, present your own witnesses if you had any, and make them come to court by court order if they would not come in voluntarily. You'd have the right to present any defenses or legal challenges you might have to these allegations. You'd have the right to either testify or stay silent regarding any matters, and you have the right to present any defenses. You understand all those matters? Have any questions about any of them? You understand you give them all up by a guilty plea? But you keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney about your decision?
Do you feel you have enough
Your
time?
attorney can't answer it for you.
Basically, yes, Your Honor.
Well, it's either yes or no.
Yes, sir.
All right. And so are you satisfied with his advice?
Yes.
That sounded like there was a question mark on the end of it.
I'm sorry, I suffer from mental health problems. I was trying to get back to a doctor immediately. It's getting worse. It's a psychosis is the problem. So lack
The
of
issue
sleep.
here is, are you satisfied with the right advice your attorney has given you?
I believe, yes, yes.
All right. Now, have you been promised anything to get you to plea? You understand this is a straight-up plea where the court has total discretion about your sentencing. And have you been threatened or made to plead when you don't want to? Have you had any medicine, drugs, or alcohol in the last 24 hours? Are you supposed to be taking some mental health medications you're not taking?
I've been denied my mental health medications for a little over 3 months now.
The fact that you have not taken your medications, is that hurting your ability to know where you are and what you're doing?
I'm at the Okaloosa County Courthouse in Crestview, Florida.
So, answer my question.
No, sir,
You know where you are and
it
what you're
doesn't,
doing,
it doesn't
correct?
affect it.
Pardon?
I said, no, sir, it doesn't affect it. Not having the medication does not affect my ability.
Okay, so you know where you are and what you're doing today? And have you been committed to a mental health facility?
I had been Baker acted. Whenever
How long did you stay?
this last time that I left the Baker Act facility, I brought in receipts.
How long were you in the
stay?
facility?
I was in the regular hospital for a week under a Baker Act, and then
Sounds like more of an observation than a formal commitment. So
they admitted me after that for a week to the Vines Hospital in Ocala.
Well, that sounds like more of a, as I said, an evaluation than a commitment. But at any rate, you're currently under the care of a mental health provider.
Oh, yes, sir.
And you're doing what's they're recommended for you, other than taking the medication you're not getting?
Yes, sir.
All right. Now, it's alleged here that you violated community control, which is a very strict form of supervision, by changing your residence without the consent of your probation officer. Officer Lewis said that on or about November 2 of last year, you moved from your last known residence of Phoenix House of Florida on North Highway 301 in Citra, Florida, without the consent of your probation officer, and there was apparently a discharge summary was submitted indicating that she didn't know where you were.
Yes, sir.
You took off without consent,
Yes, sir.
and then you were terminated from the program.
Yes, sir.
And it's also alleged that you failed to successfully complete and remain in that treatment program until the provider determined that treatment was no longer necessary, once again, based on your leaving that location. Why did you leave?
I honestly left because I was getting bullied and teased a lot.
You talked to the staff about it?
I did. I talked to a staff member before. It wasn't like I fled or departed suddenly.
Check in right away with your community control officer when you left?
I did not. I had ended up within 24 hours. I ended up back in, that was whenever I went to the hospital for mental health help, within the 24 hours. I had made my way to a local Tom Thumb.
Where did you go?
I walked and a woman picked me up, and she was going to help me get a Greyhound back home because I knew that my warrant was going to come back out in Okaloosa County for leaving.
So you didn't go to a mental health facility right away?
No, sir. This was hours later.
Here's the problem you have. When you're on community control, that's extra strict supervision. The one basic thing you're supposed to do, two basic things really, is number one, follow the orders of the court. Number two, keep your probation officer informed if some emergency comes up that prohibits you from following the orders of the court. You understand that? You did neither of those in this case. And your plea to be freely, voluntarily, knowingly, and intelligently made. There's sufficient factual basis to support the plea. And counsel, anything else you wish to present?
Just a determination from the court if the court would like to proceed to sentencing this morning. Or
Let me inquire, what's this gentleman's prior record, do you know?
Judge, if the score sheet Ms. Leone prepared is correct, these two cases are his only history. He's on his third violation of probation. I don't see any other history. Ms. Leone's offer was 2 years in the Department of Corrections.
What's his score?
It is 36.6 points. The score sheet is right.
Calculate from what you found. Yeah. 22?
Defense counsel's informed me there could be prior misdemeanors, so I would need to make sure this score sheet is correct, Your Honor. I apologize. I didn't know this was going to be a plea to the bench today, or I would have prepared Ms. Leone's files.
in all candor, Judge, I did not know either until this morning.
Counsel, do you have an idea of how many misdemeanors would be added?
At most 3. Yeah, I believe it was 3.
Prior record? It's like 0.2 of a point per, so
Correct.
maybe another 0.6 of a point.
I'm seeing one misdemeanor, contempt of court, violation of injunction, protection against domestic violence. I'm also seeing another contempt of court, violation of injunction, stalking. Those two were convictions. That should include all of his Florida history. See if he has any out-of-state history, Judge.
Looks like that would put him up to 37 total sentence points if those 3 misdemeanors were added. Or any other arrest for any new criminal law violations?
Not that I'm aware, Your Honor.
Since there hasn't been an amended affidavit submitted.
Not that I'm aware, Your Honor. My understanding of the entirety of his criminal history in the state of Florida are these 2 cases, a 2022 case where he was adjudicated guilty of a possession of paraphernalia, a 2021, or these 2 cases, and then 2 different 2020 cases involving violation of injunction where he was adjudicated guilty of 1 count each. So 2 counts total, making a total of 3 misdemeanors beyond these 2 case numbers.
All right. Well, here's the reality for you, Mr. Key. If you do have, and I'm presuming you do have mental health issues, using illegal drugs is not a way to deal with that.
Yes, sir. I understand.
Critically important.
I understand completely, and there are drugs being passed around the county jail. We've had a couple people pass away, and especially in the pod that I'm in, I actually was able to turn them down for the first time the other day, and I would have sat in to observe the mental health court and try to go that route, but I have no ride. My grandmother told me that I was not allowed because of how often that it is, and it's in Fort Walton, and that I do live in Baker. I have lived at my residence for 23 years, and I've never had an FTA, if that would be an issue. I'm trying to get out back to my mother. Her heart's working at 4%. I understand that there's not really much we can do about that at this point, but I also was needing to see a doctor as well. I was just going to humbly ask that maybe within, if we were worried about me absconding or anything like that, if we could get a reinstatement of probation, if I could leave with a GPS leg monitor. There definitely won't be any more problems with me using drugs. There has been understood talk about that in the past with me, and but this time I absolutely don't desire any. What's different with me this time is what I would have to say to you guys is that I can turn it down.
Your violations was apparently for the other intervening drug charge. You have a copy of the score sheet there? You may.
No objection to that score sheet, Your Honor.
Blessing.
All right, sir. All right, sir, at this time, I'm going to find you guilty of violating your probations. Probations will be revoked. You'll be adjudicated guilty. You'll be placed on 5 years probation. All the prior conditions, with the exception of the completion of the Phoenix House, will be reinstated. I'm going to require that you will follow through and not possess or consume any alcohol or controlled substances without a doctor's prescription. You'll only take prescribed medications in the prescribed dosage and frequency. You'll be required to submit to a mental health evaluation and follow through with any treatment that is recommended. You'll do that within 30 days of your release from custody. You will take prescribed medications only in their prescribed dosage and frequency for that matter as well. You'll be required to pay all the original fees that were ordered, plus I believe it was a single cost of prosecution for 2 VOPs, or the 2 cases. One for each. So it'd be $100 cost of prosecution fee per case, and you're entitled to a hearing about reasonable attorney fee. You need a hearing about whether the attorney's fees would be reasonable, it'd be $100 per case.
I mean, absolutely, that sounds fair, a bit more than fair.
And are you working?
No, sir.
Have you been working, I mean, when you've been out of custody?
I've had a job at Dunkin' Donuts in Panama City.
You're going to be living in Baker, finding work is going to be a little difficult. The point is
I've got a right to work.
make your best efforts at obtaining full-time employment. You'll be required to attend at least 2 AA or NA meetings per week. And you'll document that and turn that into your probation officer weekly. You'll obtain a sponsor within a reasonable time, and you'll establish a home group within a reasonable time.
Thank you.
And that's to make sure that you don't use any illegal substances while you're on custody. The problem you're getting, sir, is that if you come back again for another violation, you'll be in a presumptive state prison category. I've extended this probation a long time with credit for the time you've already served on each of these probations, with the hope that, number one, you won't violate again. Number two, giving you the incentive, knowing that you'll likely be heading to state prison if you do mess up, and that means in any way not showing up or reporting into your probation officer. If you and your grandmother have an argument and she requires you to leave the house, that day you need to get in touch with your probation officer and let them know about it and where to find you.
Yes.
It is just absolutely critical that you make your probation officer's job as easy as possible.
Yes, and I apologize.
Well, you've done it repeatedly. I can
understand.
understand everyone's concern about your ability to do it at all. But this is on you. You've been given an opportunity here, and if you mess it up, that's on you.
Okay.
Judge, may I ask clarification for the sentence? Is it bars to bed, Phoenix House? He should remain in custody until a bed is available because...
I did not order him to go back to Phoenix. I eliminated that requirement.
Okay, I think we all heard Phoenix House. Did you hear Phoenix House?
I did hear no Phoenix House, but I
Yes, ma'am.
appreciate you clearing that
Thank you for
up.
clarifying.
Everyone
There is no
heard.
Phoenix House requirement. He's
And-
going to either get this or not. I mean, he's been in enough stuff. If I get him into the 12-step community, whether that's a religious or a non-affiliated program, and you're going to need to do that right away, sir. And
Yes.
start going to meetings.
And-
They've got meetings in Baker.
Did you say a suspended sentence? I just heard you say if
No.
you go to prison.
No,
The likely score for
it's
something.
not a suspended sentence. He's going to be in a presumptive state prison category if he violates again, where he will likely face a state prison sentence. That's going to be up to the judge. This was not a suspended sentence.
Would we entertain a suspended sentence if he absconds from it again? Because I've supervised him for a long time and he's...
Considering the nature of these charges and his history, I want to give the judge full discretion to do whatever's appropriate. It's going to be on Mr. Key to make this work or not, and he'll bear the consequence if he does not make it work properly.
I will.
Or you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Thank you.
And Your Honor, just so the court's well aware, we have tried and tried and tried with Mr. Fee, and
I
he
get that.
refuses to do anything.
I get that.
Okay.
He's got to change that dynamic one way or the other, whether it's mental health based or not. He needs to check in with probation. He needs to do what he's required to do.
Thank you, Your Honor.
Thank you. Thank you, guys.
We're going to take a brief break so we can get the Zoom hearing set up.
Have a seat. Yeah, thanks, man. I appreciate it.
Right?
No, you ain't other drug.
Well, I mean...
Who's here for IT?
record?
My name is Keshante Ardnan.
How do you spell that, your first name?
First name Kshanta.
And your last name?
Nunn.
Do you know Camden Barnum?
Yes, I do.
How do you know him?
He is my nephew.
Do you know his wife?
Ritasia Barnum. Yes, I do.
How long were they married?
They have been married 13 years. They got married in 2012.
Do you know about their relationship?
I do.
Can you briefly describe their relationship?
Yes. Camden and Ritasia married in 2012. They dated all through high school. They had 2 children, Kai and 7, and Ritasia had another son that Camden has raised since before he was 1 year old. His name is Kenneth Wilson. Their relationship was rocky in the later years. On several occasions, Ritasia expressed to me that she was not fulfilled, that Camden had a life and relationships with other people that she did not have as a stay-at-home mom and also as a military spouse. I know that they loved one another. However, I think we all know that love is often not enough to sustain a relationship. But I know that they loved each other, they loved their family, and I do believe that they were working on their issues. I think they needed a lot of help.
And you mentioned that he was in the military, is that correct?
Yes.
How long was he in the military?
Maybe 4 or 5 months longer than he was married. Camden has been in since he was 18 years old. He turned 18 in April of 2012, and I took him to the MEPS office in Tampa in July of that same year.
And what branch was that, I'm sorry?
The Army.
Okay. Do you know if he's gotten any residential treatment for mental health issues?
I do. On the last time that he was in a residential facility, Ritasia called my husband and I. That was on October 19th. From my understanding, he went to, I think it's Whitmore, which is in Clearwater, Florida.
Do you know about any violence between the two people?
I knew on the night that she called my husband and I, it was October 19th, what she said to us was that she was going to shoot Camden. I know that during a visit that we had with them in 2021, I saw her hit her son in the back of the head, and I spoke to her about it, and she was upset with me because I guess she thought I was trying to tell her how to parent when I didn't. I just didn't like what I saw. I have been privy to instances such as that.
Have you known Camden to be a violent person?
Never. Camden is the kindest, sweetest, gentlest person that I know. I helped raise him. He lived with me prior to leaving to go to the military. I've spoken to countless people that he works with, from a lieutenant colonel. I've spoken to a captain. I've spoken to a first sergeant, all within the past couple of weeks, and they all have the same sentiment that I do. Camden is not a violent person. He's very mild-mannered, very even-tempered, and Camden works to avoid conflict, and he has always been that way.
Do you know where he would be able to live if he's able to place a bond on this case?
Absolutely. Camden can live here. He can live with my mother, who is here with me as well as he has a home in Crestview, Florida. And I also spoke with a Captain Barris on last Thursday, and the base is an option for Camden as well.
Where do you live?
I live in Riverview, Florida, which is in Hillsborough County.
Those are my questions. Thank you, Ms. Nunn.
Ms. Nunn, this is Brooke Davis on behalf of the state. You sounded like that Mr. Barnum has been in more than one residential mental health facility, is that right?
I know of one facility. I do know that he has sought treatment prior to that, but I know of the last time that he was in a residential facility and of his own volition.
The last time. And when was the last time?
In October of 2022.
And do you know when he was released?
In November of 2022, like mid-November.
I don't have any other questions, Judge.
Redirect.
No redirect, Your Honor, thank you.
Excused.
Yes, Your Honor.
Thank you very much. Appreciate your participation tonight.
Thank you. Have a good day.
I have no other witnesses, Your Honor.
Judge, the state would call Investigator Ralph Garrett.
Raise your right hand, please, sworn. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Please have a seat, speak up loud and clear.
Mr. Garrett, can you hear me very well?
Yes.
Okay. If at any time you can't, then just please let me know and I'll stop. Okay. Can you identify yourself for the record?
My name is Ralph Garrett. That's Garrett.
And where do you work?
The Crestview Police Department.
How long have you been there?
There I've been 7 years, 34 years with the Sheriff's Office here in Okaloosa County.
And what's your current job title?
Investigator.
Have you had previous opportunities to investigate homicides?
I have
Approximately how many homicides have you investigated?
8.
And other shooting incidents, have you had that opportunity as well?
Yes.
Approximately how many?
Probably 6 or 8. They're all a lot of shootings.
Do you have any training on investigating crime scenes?
Yes, ma'am.
Give me just a brief, what kind of training do you have?
I've been through the basic recruit back in 1978, was a crime scene investigative school. And I've had numerous other additional classes on crime scene examination, crime scene photography, evidence collection, so forth.
Investigator, you've had an opportunity to participate in the investigation in Mr. Barnum's case, is that correct?
Yes, ma'am.
You were on scene the day this was called in by 911?
28th of December, yes.
Can you give me a little bit of information about what you saw when you arrived on scene?
I arrived on scene and then I was called back to the police department at the request of Mr. Barnum. Then I left and went back with a search warrant that had been signed. The search warrant was executed. Crime scene from FDLE took control of the scene. And I stayed outside for quite a while until she allowed us to go in, which was a couple hours or so later.
What did you see inside the residence?
The residence was relatively neat, pretty well kept. They've been doing some reconstruction in the house. We were focused on the children's bedroom, where there were some bunk beds. Once I went in, first thing I noticed was, of course, the victim laying in the floor on her stomach. The bunk bed on both mattresses had a lot of blood saturated on the edge of the mattresses. And I noticed the gun, a pistol, laying between her legs on the floor.
And where was the case for the gun located?
Like a holster, is what you meant?
The box from the gun?
I don't know.
Okay. Were other children present at the time of this?
At the time of the shooting?
Yes.
Yes. At one point, they actually opened the door while things were taking place in the bedroom, and they were told to go back to.
I'm going to object on hearsay for that, Judge.
It's a bond hearing, Judge.
Understood.
Who told them to go back to where they were?
Once they were able to open the door, Mr. Barnum told them to go back to his man cave. That's what he called it to me. It's a room that's built into the garage. When the children advised when they opened the door that he was on top of their mother.
And did they explain when this happened?
They were arguing early in the morning, and based on what Mr. Barnum had said, the mother had woke them up, calling for them, and that's when he sent them to his man cave, and they went into the children's room.
And what did Mr. Barnum have to say about what happened that night?
Mr. Barnum stated that they had been arguing most of the night. He said that he tried to leave a couple of times, and his wife would not let him leave. The argument escalated continually on through the night. He mentioned that she had a pistol in a bag, that he had checked that bag, and the pistol was not present in that bag, so he didn't know where it was at. He never seen that pistol that night or that morning. But he said when he didn't see that pistol, he armed himself with his pistol.
What kind of clothes was the victim wearing?
She was wearing shorts, real tight shorts, and I believe it was just it was like a halter top.
In your experience, were these clothes sufficient to carry a concealed firearm?
No.
Go ahead, I'm sorry, I interrupted you.
Once he armed himself, they went up in the children's bedroom, and the argument continued. He says that he turned around to walk off, and he heard something, and he turned around, and she was in his face. And I asked him if she had knives, if she had guns, if she had anything in her hand that could hurt him, and he said no, he didn't see anything.
What did he do in response?
I'm sorry?
What did he do in response?
When she was in his face, it was sort of hands-on pushing. He had a mark on, I think it was his right side of his forehead, where he says her fingernail scratched him. And I don't know if that's true or not. He did have markings there. But they were pushing, and he said, I just shot her. Now, he tells me it was an accident. Told us that more than once, that it was an accident.
How many shots?
There were 4 shots fired.
Do you have any audio of this?
Yes.
What can you hear in the audio?
The neighbor across the street from their house has a Ring doorbell system, and it picked up the shots as they were fired, at least 3 of them.
Are they in a close group or?
There was 1 shot, and then probably a second and a half, maybe 2 seconds, there were another shot, and it sounded like there were 2 shots together. I mentioned to him that an accidental shooting, in all of my career, I've never known of any accidental shooting to have a pistol shot 4 times. You may shoot it once and go, whoops, I'm sorry, but his was 4 shots. But I didn't believe that.
Is there anything else in your training experience that, from the scene, that would indicate to you a lack of mistake or accident?
I'm not sure what you're asking me. Sorry.
No, it's fine. Was there anything about the body that indicated to you, or the location of the blood spatter, those types of things that in your training experience that would also be inconsistent with the statements from Mr. Barnum that this was an accident?
I don't make any judgments usually until after the autopsy. The bullet entry that actually was a fatal shot was shot while she was not looking at him. She was to the side. The right side of her body would have been facing him, and she would have been looking not toward him. So that would tell me that she wasn't aggressively after him at that point.
All right, I'm just going over my notes. Give me 1 second.
If I may, it's okay. Talking with the Department of Children and Family Investigator Hatch, she interviewed Mr. Barnum at the jail, and I believe it was like a 2-hour interview, and he explains to her that he fired 2 warning shots.
Did you find evidence of that within the bedroom?
No. There was 3 bullets struck her. 1 bullet actually hit the floor just above the baseboard behind the bed, which, in my opinion, he just missed her. I don't believe it was a warning shot of any kind.
Have you also had contact with Army JAG?
I have.
Was there any orders prior to this regarding contact with Mr. and Mrs. Barnum?
There was none at the time. I'm not sure if there were in the past. One of the reports that CID was able to get from me was an incident that took place in Hawaii when they were stationed over there. They got into a domestic situation where he had supposedly drug her down the stairs by the hair of the head. And corroborating some of that here in this county, she worked at a liquor store on Eglin called the Classics, and she missed like 3 days of work. And I interviewed the manager that she worked for. She showed back up to work after about 3 days. She had pictures of her head on her camera, and she also showed her manager where Mr. Barnum had supposedly pulled hair out of her head as the reason she didn't come to work.
I don't have any other questions, Judge.
Cross-examination.
Thank you, Your Honor. Go to my notes. You said the residence was relatively neat, correct?
I'm sorry?
You said the residence was relatively neat earlier?
It's average.
Okay. Did you go into that man cave area?
Yes.
Did you notice anything in particular about the door jamb or the door frame?
I didn't remember seeing that. I'm sure it's photographed. I think it was a broken door frame or something.
The door frame was broken?
I believe so. I can't tell you that for certain.
Do you remember if the door was actually able to latch at all?
I don't know.
Okay. But that was his area, right, Mr. Barnum's area, that room in the house?
That was his man cave, as he said, yeah.
Did you actually look at the body at all? Whenever
Yes.
you went to the room? Did you see any signs of attempts at something like CPR or resuscitation?
No. He didn't say he did that. He just said he tried to pick her up and later back, he knew she was gone.
Did he describe anything beyond just a struggle when he talked to you?
As far as?
As far as if she had tried to reach for his gun or anything like that?
No, I've never heard that.
Those are my questions. Your Honor, I'm sorry. Those are my questions to this witness, Your Honor.
Investigator Garrett, the children, did they mention anything regarding any of the doors and prior to seeing Mr. Barnum on top of Miss Barnum?
The 13-year-old child, which is, I guess, his stepson, the younger child, the 13-year-old is having problems right now talking about this. The younger child said that the 13-year-old actually picked the lock. The door was locked. And so he picked the lock to get into the room.
Which door? Which room?
Their room, the children's room.
The bunk beds where the victim was discovered?
Correct.
I don't have any other questions, Judge.
No follow-up, Judge.
Yes, Judge.
Objection?
No, he can be excused, Your Honor.
Thank you, sir. You may step down.
Your Honor, in speaking with my client, he does wish to testify today. I've advised him against it, but he has made the decision that he would like to testify. I've explained that that puts him at risk of cross-examination.
Or just to reinstate or restate the matter, you have the right to remain silent. If you say anything incriminating, it could be used against you. Do you understand that? By testifying here today, you'd be waiving any objection to having that presented against you. Usually a good idea to listen to your attorney's advice. So how do you wish to proceed?
Do you not want us to, you don't want to testify?
No, I'm fine.
Okay. All right.
All right. So, counsel, anything else then from the state?
No, Judge.
Defense?
Just argument, just reiterating our argument from earlier, Judge.
Judge, I do want to make clear, this is a capital case. Mr. Barnum is not entitled to a bond. The state has filed a second-degree murder charge against Mr. Barnum. That is a life felony. That is a capital case. So he's not entitled to a bond at this point. Judge, this time...
Second-degree murder is a felony first degree, potentially punishable by life.
Right.
It's not a capital case per se.
It's a life exposure.
Yes, it is.
Judge, Mr. Barnum has made clear in his statements to police that instead of calling the police, asking for help throughout this supposed arguing throughout the night, that he made the decision to keep the children in the home, he made the decision to get his gun, he made the decision to go into a small room with the victim while he was armed, knowing she was unarmed, and continued to argue. The children have explained that the two of them were locked in the bedroom together. They had to pick the lock to get in and saw Mr. Barnum on top of Miss Barnum. He didn't leave the area. He chose to arm himself with a pistol. He shot his wife multiple times. He has confessed to that. So that is very clear in his statements. We have somebody who is a risk to the community. He was just recently released from a residential mental health facility, as testified to by Ms. Nunn. That's very concerning for the state that we have somebody that has a serious mental health problem, went to a residential facility, was only recently out, and is now in a position of causing the death of his wife. I am a little confused from the motion to set bond that was filed by the defense, as far as that Mr. Barnum was going to be living at the residence, because I have received phone calls from a realtor that someone is attempting to sell the house right now. So I don't see how Mr. Barnum is going to be living at the house at the moment. It's in the process of being sold. Mr. Barnum is quickly going to be relieved of his military obligations. They are working very hard. I have had multiple communications from JAG. They are trying very hard to prepare the case to dismiss him from the military immediately. So they're also looking at other charges against him on the UCMJ side as well, Judge, including child endangerment, because the children were present in the home at the time. So as far as the children goes, Mr. Barnum does not have an interest in getting out in order to take care of the children. As the defense has noted in their motion to set bond, there's been an emergency custody already handled, so Mr. Barnum does not have custody of the children at this point. They are in another state right now being cared for. Other than that, other than his military ties to the community, Mr. Barnum has no other ties to this area. The closest that he has any relative is going to be in Hillsborough County. He has no reason to stay here and face these charges that are presented before this court, Judge. At this point, the state would believe that Mr. Barnum is not entitled to a bond. He shouldn't receive a bond. If Your Honor is going to give him a bond, we definitely believe, based on the need to protect the community, that this is an extremely high bond, at least $1 million, Judge.
Your Honor, as you pointed out, this is not a capital offense. He is entitled to a bond. The state mentioned at some earlier that, he was in a residential treatment facility. I believe we also had alluded to that. The state says that they're very concerned about him being there. However, there's no indication that he was, say, kicked out or failed out of that program. It seems otherwise that he had completed that program successfully. It seems that the state is being concerned that he was in a residential mental health treatment program. The state's basically saying that they're concerned that they didn't even do their job, despite the fact that he's been released from that program. He is seeking therapy. He was seeking therapy. That would be something that he would be still trying to do. As far as him living in the house, Your Honor, yes, he is aware that the house is being put up for sale. That is a process that is happening. He understands that. He is working with that as well. He would live there potentially while the house is waiting to be sold. In addition, he would also again, possibility of being remanded to the base. I know Ms. Davis says that the military is kicking him out as quickly as possible, instigating UCMJ proceedings against him. And yes, he could potentially live with his aunt in Hillsborough County. He doesn't have any criminal history, therefore he has no FTAs. I don't have any concern that he would miss court. I don't have any concern that he would not show to court whenever he's required. I believe that he is very invested in his defense, very invested in seeing this case through to the end. However we get to that point, would not be a flight risk at this point. And again, we have no objection to a GPS. I don't even believe that he actually has a civil passport, as far as I know. But we would have no objection to GPS, pretrial supervision at a $50,000 cash or professional bond. The state said that, he's not getting out to take care of his children. Of course, he can't have contact with them right now anyway, and I would imagine the court would impose that sort of a bond, considering in the allegations that the children were in the home during this incident. And in fact, of course, again, there was an emergency custody hearing made by the children's maternal grandmother. So I doubt that he would have any sort of access to them anyway if he was out. That was done beyond him. I believe that was done ex parte, and an emergency hearing was done. I have no reason to believe that he is going to miss court. I have no reason to believe that he won't be invested. In fact, I fully believe that he would be invested in his defense. He is entitled to a bond, and that's why we're asking for a $50,000 cash professional bond.
Motion for bond, set bond is granted. I'll set bond the amount of $500,000 cash and professional. Condition of the bonds, the defendant will remain within the confines of the state of Florida. If he makes his bond, he'll have no contact with the children whatsoever. That means in person or by telephone while this case is pending. They're alleged collateral victims of this offense as well. And that's the order of the court. Counsel, if you will, would you please approach?
Mr. Barnum as well?
Yes.
And that would be at $1 a day?
And that's so he would be on pretrial supervision, Judge.
Correct.
And surrender any passport?
He indicated he doesn't have one, but if he does, I'm going to order that he surrender any passport as well.
We would ask that Mr. Barnum not possess any weapons of any kind, Judge.
I think that's a requirement of Florida law under these cases, if I'm mistaken, but I'll order that he will not possess any weapons or firearms of any kind.
He would need to surrender any in his possession, Judge, within 48 hours, 24 hours, 48 hours of release.
Assume that any firearms in the house were seized as a part of the investigation. But to the extent that they were not, and he has any anywhere, then he needs to surrender to law enforcement within 48 hours of his release. In addition, he'll be required to follow up with any mental health treatment if he's currently under the care of a mental health provider. That includes taking prescribed medication as prescribed.
We'd also ask no drugs or alcohol. I believe that on scene there was some cannabis that was located.
No consumption of any drugs or alcohol without a doctor's prescription.
So in order to enforce that, Judge, we'd ask for random urinalysis and breath test.
So ordered. Thank you.
Thank you, Your Honor. Yes, thank you for reminding me. He is set this afternoon, Judge, for arraignments. We will also go ahead and tender a not guilty plea, Judge. Ask for 15 days to file any pre-arraignment motions and demand trial by jury.
Request regarding pre-arraignment motions is granted. He's set for jury trial.
That's fine. We can leave him on pre-trial for that day. Thank you, Your Honor.
Judge, I have nothing else before this court today, if I may be excused. Thank you.
All right. Someone else have a case ready? We're going to go into the afternoon docket if we...
Judge, I have Ms. Moran available, or are we still working on Tim's cases?
That's fine. I'm sorry. I know, we're all anxious.
I'm just trying to keep there from being dead mic.
Your Honor, this is going to be Mr. Tiandre Fournier. Judge, case number is going to be 22 CF 1191. Your Honor, we have reached an agreement with the state in this matter. If I may approach with a written plea.
Do you swear affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, sir. 20, I have a written plea agreement here regarding a violation of probation, and is this your signature on that agreement? Did you read all this document before you signed it? Do you have any questions about anything in it? Do you understand everything in it? You understand that by entering your plea, you're giving up your right to a violation hearing, all of your violation hearing rights, and the right to appeal whether you're guilty of this matter. But you keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney about your decision? Are you satisfied with the advice given?
Yes, sir.
Has anyone promised you anything to get you to plead?
Yes, sir.
What have you been promised?
Have you been promised anything else outside of that agreement?
Other than what's in your agreement? You've been promised anything other than what is in this agreement?
No, sir.
All right. Have you been threatened or made to plead when you don't want to?
No, sir.
Have you had a medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Have you ever been committed to a mental health facility?
No, sir.
And counsel, are there any pending criminal charges or just these VOP allegations?
Judge, the VOP allegation comes from an involvement that he was in Atmore, Alabama. He was not arrested or charged with any crimes in Atmore, Alabama. The basis of the violation of probation includes association with those engaged in criminal activity. I believe at least one of the other individuals that he was with at that time were arrested, I believe, on firearms charges as well as drug charges. That is the basis for this violation of probation, Judge.
Well, there's an allegation that he possessed a firearm here for the VOP.
Looking at the police report from that, Your Honor, I do have a copy of it. I provided it.
All I can deal with is the allegation in the VOP right now. Is he pleading to that or not? That's allegation one.
It didn't show that he actually had actual or constructive possession of the firearm, Judge. That was, and so the agreement with the state on this, Ms. Leone, who's unfortunately not here this morning, that was because of that, that was one of the reasons that we had reached this agreement on this case, was due to the allegation of being engaged with, or associated with those engaged in criminal activity, but not that he had actually possessed a firearm.
The affidavit alleges that Officer Allen, the probation officer, stated that, according to Officer Darrell McMahon of the Atmore Police Department, the defendant did possess a tan Glock 9mm. That's the allegation that we're dealing with. He does not have to plead to that if he doesn't want to. This is the allegation that he would be admitting if he wishes to plead to it.
Plead to that allegation. Judge, he does not want to plead to that allegation.
He will plead to being with persons engaged in criminal activity?
Yes, Your Honor.
Allegation two? Okay. So, sir, what happened about your being around for that you says you're associated with Leighton Fry, who was engaged in criminal activity based on his arrest for possession of marijuana and drug paraphernalia?
Yeah.
With him?
Yeah.
You know that he was involved in that kind of criminal activity?
Yeah.
Didn't do that while you were on probation?
Yeah.
And had you been allowed to transfer up to Alabama on your probation? So you were out of state without permission too. That's not alleged here, but at any rate, the point is you got to do what you're supposed to do on probation. You understand that? And that means follow the rules. And how does the state want to proceed on allegation one?
Your Honor, it's acceptable that we will take his admission to the violation on count number 2.
All right. So you're willing to forego any proceedings on number 1?
Yes, Your Honor.
In the absence of evidence, allegation 1 is dismissed. And this time, sir, I'll find you guilty of violating your probation. Do we have a score sheet?
Your Honor, unfortunately, the one I have it's handwritten, and I don't feel comfortable giving it to the court, but I will indicate to the court that it does reflect 38.8 points, sentencing points, as the minimum points, and a maximum of 6 years incarceration, Your Honor.
That sounds accurate, Judge, and so I don't have an objection.
We can get that to Madam
The
Clerk.
score sheet I have showed 28.8 points.
Yes, Your Honor, that does not reflect, that's the previous score sheet on the original plea, and that does not include the 6 violation points that we would add for a VOP. That would then, oh, and also, no, she had legal status points in there as well. That was the word 38.8 came from.
Is there any objection to that?
No objection, Judge.
You can submit a score sheet
I
for
will do that.
signing.
I do want to verify.
Bring that up this afternoon. I can sign it this afternoon. Or have someone bring it up for you, please.
We will, Your Honor. I do want to verify, though, I'm sorry I didn't verify this sooner, but one of the conditions that we're asking that Mr. Forney include and admit to is cost of transportation of $146.29.
Any objection? That's a sentencing issue.
They're just going to assess that, and that'll be part of the court cost that you pay. That's fine?
I just didn't want us to forget it.
That's fine, Judge. How much was that?
Down here, all monies. So, anyway, sir, you'll be required to serve 5 months in the county jail with credit for time served. Probation will terminate upon your release from custody. You'll pay $100 cost of prosecution, and the costs of transportation, which is, once again, how much?
Your Honor, that was $146.29.
It's payable to the Okaloosa County Sheriff's Department.
Yes, Your Honor, thank you.
And, sir, you're entitled to a hearing regarding reasonable attorney's fees. There's an application fee of $50 and typically a $100 public defender fee for a felony probation violation. You need a hearing about a reasonable attorney fee? Pardon?
He's asking if you believe that the $100 is a reasonable attorney fee.
All right. Then I'll find that you've waived your right to a hearing regarding a reasonable attorney fee. A $50 application fee plus a $100 public defender fee is assessed. You pay the monetary obligations within 180 days of your release from custody. If you don't pay it all by the end of the 180 days, you need to go to the clerk's office before the 180 days expires and set up a payment plan. You understand that?
Yeah.
All right, sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Morning. Morning. Probation needs to see Forney. Your Honor, this is Ms. Nicole Grant. Tim Gibbs on her behalf in 21 CF 3037, 23 CF 190. Your Honor, I believe we reached a written agreement with the state. I'm just going to review that written plea with her one more time. You want to do?
Yeah.
Do you have any other questions?
No.
What you want to do is sign right there for me, please.
Check out the soaps, bath bombs, and other bath and body products.
if I may approach for the written
By
plea.
hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard.
Yeah, it's a VP animal. Worksheets included, Judge, no objection to this worksheet.
So I'm curious about the recommendation on the 2021 case.
Okay.
I have a question for the state and defense counsel. On the 2021 case, you've got the sanction would be imposing a 30-day suspended sentence.
Lifting the suspension, Judge, and sentencing her to 30 days, yes, Judge.
Does she have credit for time served equal to that?
I believe she has at least 25 days on this arrest, so that should get her there.
It was just, there was no following supervision, so.
Yes, Judge.
So there was a previous 30-day sentence suspended?
Correct.
That needs to be imposed? Correct. Got it. All right, ma'am, if you'll raise your right hand to be sworn. You swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Nicole Grant.
Ms. Grant, I have a written plea agreement regarding a violation of probation here and a new case. And is this your signature on that plea agreement?
Yes, Your Honor.
Did you read all this document before you signed it?
Yes.
Do you have any questions about anything in it?
No.
Do you understand everything in it?
Yes.
You understand that by entering your plea, you're giving up your right to a violation hearing on the VOP and to a jury trial on the new charges.
Yes.
You're giving up all of your hearing rights and the right to appeal guilt. There are different rights in these cases. The VOP, you'd have a burden of proof for the state of only the greater weight of the evidence, and the right to remain silent other than on technical violations. Well, on the criminal charges, you'd have the right to a jury trial. You'd have the burden of proof of guilt beyond every reasonable doubt. That's the highest amount of proof it would take to prove any fact in the court system. And you'd have the right to remain silent on any criminal law violation. You understand those differences?
Yes.
Otherwise, all the rights are the same between the two proceedings. And have you had enough time to talk to your attorney about your decision?
Yes.
Are you satisfied with the advice given?
Yes, Your Honor.
Does anyone promise you anything other than what is in your agreement to get you to plead?
No.
Have you been threatened or made to plead when you don't want to?
No.
Got any medicine, drugs, or alcohol in the last 24 hours?
No.
Ever been committed to a mental health facility? You've got, looks like 24 alleged violations of probation. You've got these new charges. You've got failure to do some paying the DC Trading Trust Fund fee, failing to pay your cost of supervision, drug testing fees, court costs, completing community service on multiple occasions. Failure to get an evaluation for drugs or alcohol problems, failing to comply with instructions beginning in October to provide medical and hospital documentation, failing to perform job searches, and then starting on October 1st, followed by October 10, 14, 18, failing to report to your probation officer as directed. And then on allegation number 8, it's alleged that you failed to perform job searches on October 19 through November 4, failed to visit the probation office on November 4, November 21, failed to do job searches November 28 through December 7, failed to report on December 7, December 13, and December 28. So multiple failures to comply with your basic obligation to report in and do other things that the court ordered you to do. Why didn't you do them?
So before I came to jail, I was struggling with an addiction, and since I've been in jail, I've gotten clean and realized that I want to be clean and live. So I feel like once I get out, if I get out today, I'll be able to follow through with everything that I need to do because I have a clear head.
How long have you been in jail now?
26 days today.
What was your substance of preference? What would you like to use?
Opiates. Opiates was my thing. And I've been trying to get clean now for 2 years, and I'm finally clean. And
Any new charges involve fentanyl and methamphetamine? Fentanyl is incredibly dangerous, and methamphetamine is likewise dangerous and incredibly toxic. It can harm your body in terrible ways. And you can die from an overdose of fentanyl, which is easy to have happen. The point is, 26 days is just a scratch at a beginning of recovery. It's no guarantee that you won't use again. And here's the reality. If you, so did you have, why were you arrested back on January 16th?
why was I arrested?
When you had the fentanyl and the methamphetamine, how were you in touch with the police?
I was in a car.
Okay, so they stopped the car? Yeah, were you driving?
Say that again?
Were you driving?
Yes, I mean, I was in the car, yeah.
Were you driving?
Were you the driver?
Yes.
And did they tell you why they stopped you?
I didn't stop all the way at the stop sign.
Is that true?
I don't think so, but
Well, you'd have the right to contest that, and you might have a legal issue here if you weren't properly detained. Do you understand that? And you're giving up that possible issue by entering this plea. Do you understand that?
yes, sir.
And do you think that's best to deal with it that way?
Yes, sir.
And how was it they found the drugs in the car?
Search the car.
Did they ask you for permission to search? How did they find them then?
They just told me to get out the car, and they were searching the car.
Say it again.
They just told me to get out the car, and they searched the car.
I believe there was a canine sniff, Your Honor.
Was there a canine there, a dog?
Yes.
Do you know whether or not the dog alerted on the car? Don't know. There may be a legal issue there as well. Typically, traffic stops are not a justification to search a vehicle under the law. You understand that? But the point is, you may be giving up legal issues by entering your plea today on the new charges. Do you understand that?
Yes, Your Honor.
You think that's best? You have to make the decision, man.
Yes.
The attorney's here to give you his best advice.
Yeah.
But in the end, you have to choose.
Your Honor, I do.
You'll find your plea in these matters to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea, and you're waiving any possible legal issues or defenses on the new charges. Yeah, and the last three allegations of the VOP. At this time, is there any objection to the score sheet with
No, Your Honor, if I may approach.
3.2 total sentence points?
If I may approach, there is.
It's 35.8. So, ma'am, I do want to let you know that if you mess up this probation and you come back, you'll be getting close to the possibility, and the judge may decide to go ahead and send you to prison because you'll be over 40 points. It's 40, after 44 points, you're in a presumptive state prison category. You understand that?
Yes, Your Honor.
You're messing up your life, number one, by getting arrested for illegal stuff, and then, most importantly, by putting your life at risk by taking illegal drugs and harming your health. And at this time, we'll find that you're guilty of violating your probation. Your probation will be revoked. You'll be required to serve a 30-day county jail sentence with credit for time served. You'll pay a $50 cost prosecution fee and a $100 public defender fee, and any monetary obligations of this case will be payable during the time you're on supervision in case 23 CF 190. On the new case, you'll be sentenced to a year of drug court probation on each count concurrent, followed by a year of standard probation. You pay $515 in court costs, a $100 cost prosecution fee, and be required to submit to a substance abuse evaluation, and within 30 days, if any treatment is recommended, you'll start the treatment within 30 days of the recommendation. You'll continuously attend and successfully complete the treatment as well as any aftercare. You'll not possess or consume any alcohol or controlled substances without a doctor's prescription, and submit to random sampling to verify compliance. You'll perform 24 hours of community service work, and you'll attend at least one AA or NA meeting per week during the first 6 months of your probation. You're entitled to a hearing regarding reasonable attorney fees. Do you need a hearing about that?
No, Your Honor.
All right, you'll pay a $50 public defender application fee if unpaid, plus a $100 public defender fee on the new case. Once again, I'll find retroactively that you waived a hearing regarding PD fees on the VOP. That $100 fee is assessed there. I'm sorry, that was a misdemeanor probation that she was on, is that
Correct, Your Honor.
That'll be a $50 application fee if unpaid, and a $50 attorney fee.
To be clear, Judge, I believe that's drug offender probation. It's a particular level that probation uses. I think you may have said drug court probation earlier. But it's drug offender probation.
I apologize if I did, it's drug offender probation.
Thank you, Your Honor.
thought
And
I said
we'd request those
correctly.
supervision, I'm sorry, Your Honor. We'd request those supervision fees be waived considering she has been found indigent.
Probation agree? Yes, sir. Granted. All right, ma'am, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
All right, thank you.
Thank you, by staying clean and sober. In addition, miss, excuse me,
Ma'am, Ms. Grant.
you're going to also require that, along with the AA, that you get into a home and get a sponsor in
Okay.
substance abuse treatment. I'd encourage you, it's not a requirement of this plea agreement, I would encourage you to keep those and keep going to meetings even after 6 months, because that's a big key to having a better future.
Thank you.
Thank you, Your Honor.
Case, please. Who is this, please?
Your Honor, Tim Gibbs on behalf of Ted Grice, 20 CF 406, 20 CF 1727, 21 CF 934. I'm going to have just one more. So, yeah. Again, that's the plan. Okay. That's the plan. You're okay with put that sign right there for me, please? She did. And hold on. This is the one. This is.
Excuse me.
She did. I had a copy of it. Just print out a copy of this question.
Is that cost of transportation?
No, it's not. But how much is that? Get in there. Oh. Oh. No, okay. They're going to want to do that. I had to clear it with you because you have a right to contest that. No, you're fine with that? Okay. Oh, Your Honor, we have reached an agreement with the state in these cases. If I may approach with a written plea and a score sheet. Review the score sheet, Judge. There's no objection. He's going to ask.
Appears that we have another case on here that was not on the docket for Mr. Grice.
What case number do you see, Judge?
2020 CF 1727, apparently a VOP.
I did have the affidavit. Does the clerk not have that case number? It's set for the 28th? Okay. It's just on a later docket? Okay. It's just on a later docket, Judge. We'd like to resolve them all today.
They'd have any objection? Do you have that file here by
I
any
do, Your
chance?
Honor. We have all three, and all three have been included on the score sheet as well.
Yes. I presumed they were, but I just wanted to double check.
Yes, sir.
Thank you, Judge.
All right. At any rate, sir, if you'll raise your right hand and be sworn. You swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
State your name, sir.
Ted Dexter Grice.
Mr. Grice, I understand you want to plead to two cases where you have violations of probation and a new case involving possession of alprazolam and driving with your license suspended or revoked, third or subsequent offense. Is that what you wish to do?
Yes, sir.
All right. I have the plea agreement here. Is this your signature on it?
Yes, sir.
Did you sign it today?
Yes, sir, I just signed.
You have any objection if I put in today's date? You didn't put the date on it.
No, I'm sorry, sir, I didn't.
All right.
Thank you, Your Honor.
Yes, sir. Thank you.
And sir, did you read all this document before you signed it?
Yes, sir.
Do you have any questions about anything in it?
Just that I should be able to go home today?
The defendant should have enough credit for day to day, so day for day. So I can't guarantee it, but I presume that to be true based on counsel's representations. If you have to stay another day or two, does that change your decision about whether you want to take this?
No, sir, I mean, if it's a day or two, I mean, I locked up, I'm sick and I'd be home with my family.
At any rate, if it's more than that, what's your
If it's more than that, Judge, we have ways that we can address it, either through a modification or anything like that at a later time.
At any rate, sir, excuse me a moment. So the point is, sir, these different proceedings have different burdens of proof. You might not appreciate that from this paperwork, but on a VOP, the state would only have to prove your guilt by the greater weight of the evidence. That's a fairly low amount of proof. You'd have the right to a violation hearing. On the new charges, you'd have the right to a jury trial, and the state would have to prove guilt beyond every reasonable doubt. That's the highest amount of proof it takes to prove any fact in the court system. You understand those differences?
Yes, sir. I just like to get it all dissolved today.
That's your privilege. The point is, all the other rights that are explained in this plea agreement are equal between those two proceedings.
Yes, sir.
Okay? So do you understand you're giving up all your right to a trial, your right to a violation hearing, and all those rights?
Yes, sir.
But you keep the right to appeal fundamental issues or issues on sentencing errors. Have you had enough time to talk to your attorney about your decision?
Yes, sir.
Are you satisfied with the advice given?
Yes, sir. Yes, sir, I sure
Has
am.
anyone promised you anything other than what's in this
No,
agreement
sir.
to get you to plead?
No, sir.
Have you been threatened or made to plead when you don't want to?
No, sir.
Have you had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Have you ever been committed to a mental health facility?
No, sir.
So tell me about driving when you got arrested for the last offense here and the possession of drugs.
I was on,
Back in 2021, apparently.
in 2021. You know, I've got a drug problem that I plan on addressing when I do get out. I'm going.
Why were you stopped for that driving charge?
Why was I stopped?
Yes.
Oh, I was on a moped. The first, I got put on probation for driving, suspended driver's license, and I was driving a moped.
Did it have a tag on it?
It didn't have a tag on it.
Got it. So
And
they stopped you for no tag.
It was a 49cc motorcycle, and I didn't think that's the reason I bought it, to purchase it, because I figured I might could ride back and forth to work on it. But it was my,
But it's got a lot lower
Yes, sir.
CCs than that. The
Yes,
point is, but you, I don't think they require a driver's license, but at any rate,
I was ignorant to the law, and then, but I'm aware of it now, Your Honor, and I was in the wrong, so I just,
okay, you need to educate yourself on it.
yes, sir.
And what about having the drugs on you? How'd they find them?
I voluntarily give them to the officer.
And that was illegal? They were not prescribed for you?
It wasn't prescribed to me, no, sir.
And then in your VOP, you've got those along with other allegations in Walton County?
Yes, sir.
Possession of drugs?
Yes, sir, that's why I just got out of prison. They come to and got me from prison. I ain't been out yet.
You resolved all those charges?
Yes, sir.
That's it. All right. And so at this time, I find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support your plea, and have the score sheet with 43.7 total sentence points, and you understand second. Well, hopefully you don't have to go back to DOC on this sentence, that they'll let, if there is any remaining time, let that expire.
That's the consideration.
That's
Your
what I
Honor,
was trying to figure out
that,
today.
Ms. Leone and I stipulated to, that was his arrest date in Walton County, and we weren't able to get him transported over here to try to resolve this while he was still in DOC.
And
So at this time, sir, I'll find you guilty of violating your probations. Those probations will be revoked. You'll be adjudicated guilty on those matters as well as on the new charges. You'll be sentenced to 16 months in the state prison on each count of each case concurrent with credit for time served, starting October 11, 2021. So you get credit from that date. You'll be required to pay $300 costs of prosecution, plus $515 in court costs. You'll pay $491.83 costs of transportation, and then you're entitled to a hearing regarding reasonable attorney fees. With the three cases, you'd have a $300 attorney fee plus a $50 application fee. Do you need a hearing about whether those fees are reasonable?
That's reasonable, Judge.
They're reasonable?
Yes.
All right. Then I'll assess the $50 application fee and $300, $100 per case public defender fee.
Yes.
And, sir, if you've had a substance issue, have you been in any treatment before?
Yes, sir, I've been in treatment before, but I've talked before, when I was in Walton County Jail, I was talking to the man about going to the Jada House in Fort Walton. And,
Well,
that's where I want to go.
If you can't get in there, I'd recommend you get yourself involved in
Yes.
the AA or NA community.
Yes, sir, I've been in the AA
Or get
before.
your own group.
Yes, sir, that's what I'm going to.
And don't ever use it again, no matter what the trigger.
Yes, sir.
You know, if you lose a family member, somebody dies.
Yeah, they have.
If you get hurt, you know, if you lose a job, you know, there is no good excuse to use drugs
Right.
ever again.
Yes, sir.
And here's your other challenge. I don't care if you're working really hard on your recovery and doing it well, 40 years from now of clean living, you could encounter something that would trigger an urge to use, and if you're not in real recovery again, you're going to go use, in all
Yes.
likelihood.
Yes, sir.
And that's a terrible thing to have happen,
Yes, sir.
but it surely does happen.
That's what's wrong with me now, is that I've got bad liver.
Well, that's even a greater reason to never use again,
Yes, sir.
anything, drugs or alcohol.
Yes, sir.
All right, sir, you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
And for the record, Your Honor, he does have, I believe, an FTA for this that he received because he
State
wasn't
want to proceed
custody.
on that?
No action on any FTAs for the three cases that he pled out today.
Thank you. They'll be discussed.
Thank you.
What about,
All right.
Okay.
The jailhouse calculator. Yeah. So just go see the deputy. Your Honor, Tim Gibbs on behalf of Cameron Vance, 21 CF 1683. Your Honor, we're requesting to continue this matter without subpoenas to February 28th.
Objection.
Is that all right with you, Mr. Vance?
Because we're,
All right, sir. All right, no, February 28th.
Your Honor, I believe that concludes my business this morning.
And Your Honor, if I may, before Mr. Gibbs leaves, we had Ms. Tondre Fornoy that I owe the court a disclosure on. I'm going to show it to Mr. Gibbs. May I approach, Your Honor?
You may.
This young lady is sentenced.
He was, as a gentleman.
I'm sorry, it's a gentleman, I was wrong.
He was.
All right.
Yes, please.
Sorry, what was that? Jay, did you want to call Ms. Lewis back?
Yes. Judge, I've got two matters. Sorry, Judge, trigger's getting a little low.
Go ahead.
We still have Ms. Lewis to conclude. It does not look like the address she provided is going to work. So if we can get her out, I'm going to move to continue her.
Yeah, she was to be a stay here. is all I recall.
And just so you know who's on deck, Amber Moran is going to be on deck. Or I can call her, she's ready. Ms. Lewis isn't. Basically, whichever one's easier for you guys. Judge, the address that she gave is not going to work. It's within 1,000 feet of a school or place of worship, and the individual that she named is not acceptable to probation or the state. I'm willing to keep trying to work on this, but it doesn't look like we're going to be able to resolve it today. So I would ask to pass it until the 28th. And I'll come back out and try to get some additional names from Ms. Lewis within the next few days, probably next week.
Listen, you can think of any family or friends or anyone who might be able to help, and let Mr. Williams know.
Yes, sir.
And try to find out, if you can, whether they're within 1,000 feet of a school or, church or anything like that. That could be a problem for you with your classification.
When we ran the address today, that was the issue.
Got it. All right, next case, please.
Next case I have is Amber Moran, Moran. It's 2018 CF 2603. Judge, we were originally appointed fairly recently to represent her. She had been in communication with a private firm. Apparently, agreements were not able to be made, but there was a plea offer extended. I met with her. I was made aware of the offer and met with her a little while ago in the lockup area. I did go over, or attempt to go over with this, what the specific allegations were and any possible defenses that she might have. She did not want to go over that. She just wants to accept the plea agreement. I've explained to her that that's her right, but that, I'm available to go over and talk with her about the underlying allegations and any...
Did you inform her that I'll be inquiring about them?
I did. Judge, I have gone over with her what the rights are that she has and the different burden of proof and the lack of a right to jury trial in a violation of probation proceeding. There's no pass-through back there, so I was unable to get her signature on it. She'll have to sign it out here. I did explain to her that I would go out and draft it up. They had actually drafted something up, but I don't have a printer here at the courthouse to send that to. So I've had to redo it by hand. Well, you are the first judge since I've come back to the criminal practice that has not mentioned that my handwriting is,
I haven't seen it yet.
if not the worst, it is the second worst.
Do you have the score sheet, Mr. Williams?
I've ever seen. Oh, I'm sorry. I do have a score sheet. Well, and I'll present that.
It's a challenge.
It always has been, but it's gotten worse as I've gotten older.
Ma'am, if you'll raise your right hand to be sworn, please. Do you swear affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right. And state your name, please.
Amber Moran?
Ms. Moran, I have a written plea agreement, and I just saw you, or it looked like you were signing. Is this your signature on there?
Yes, sir, it is.
And was all of this explained to you earlier this morning?
Yes, sir, it was.
And did you have a chance to read it? Not really?
I don't think she's had a chance to read it, but I've explained to her what her rights are.
The point is, ma'am, you have the right to your violation hearing. That's a hearing, it's not a jury trial. The judge would hear evidence. The state would have to prove by what's called the greater weight of the evidence whether you violated these conditions that you're accused of violating. You'd have the right to bring in your own witnesses, make them come to court by court order if they would not come in voluntarily. You'd have the right to confront the witnesses the state would use to prove these allegations. You'd have the right to testify or stay silent except on technical issues.
Okay, cool. Well, she wasn't told.
And you'd have the right to
Continue there anyway.
present any defenses or legal challenges you might have to any of them. And if you had enough time to talk to your attorney about this matter,
Yes, sir.
are you satisfied with his advice?
Yes, sir.
Does anyone promise you anything other than what is in this agreement to get you to plead?
No, sir.
Have you been threatened or made to plead when you don't want to?
No, sir.
Had any medicine, drugs, or alcohol in the last 24 hours?
No, sir.
Ever been committed to a mental health facility?
No, sir.
And looks like the first allegation is that you were instructed to report to your probation officer Apparently on November 1, you were told that, and you were supposed to report on November 2, but you did not. Once again, it's alleged that you failed to, on November 3, you were told to come in on November 7, but you did not. Then apparently you refused to submit a random urine test on November 7th. It's also alleged here that you, on February 4th of 2021, those other matters were in 2022, but it's alleged back in 2021 that you were instructed to make your IOTS report and carry out their instruction by failing to call in November 22. Also failing to pay $826 in court costs. And finally, failing to complete your substance abuse treatment program or attend sessions at Bridgeway. What happened?
You can go ahead and tell the judge the things that you did, or those things.
I did pay the court costs. I paid almost $700 in court costs when I first got out of my 1129. Back in, I'm not exactly sure when it was that I completed my 1129, but I did pay court costs as soon as I got out. So it should have, I can see it on the clerk of court website when I pull it up on my own self. The rest of it, the failure to submit, I was reporting on the IOTS program. So, I mean, I never seen a probation officer hardly. So he did come to my house and had me sign some papers. And so, I mean, but other than that, I mean, the IOTS program never told me to come in to do the drug test.
Well, you may have a defense on that allegation then.
Your Honor, honestly, I've had a problem, and I do believe that the community control is the best thing for me. It's one of the best things for me to get my act together. Not only that, but I have a son at home who desperately needs my attention, and I need to be there for him. So I'm at home all the time anyways. It is the best call for everything, yes, sir.
So you're willing to waive any defenses and just get this matter behind you?
Yes, sir, I do.
Find your plea to be freely, voluntarily, knowingly, and intelligently made. There's a sufficient factual basis to support the plea. I have a score sheet with 22.4 total sentence points. Any objection?
No objection, Judge. I did discuss the score sheet with him. Basically, I think the two offenses that are scored as prior record were, went along with this case, but she's completed her requirements on that.
All right, ma'am. At this time, I'll find you guilty of violating your probation. You'll be adjudicated guilty. You'll be, say, restore and extend probation for 3 months. And convert the remaining probationary period to community control, is the way this reads. Probation, understand that?
I heard reinstate.
Says restore and extend probation for 3 months and convert the remaining probation to community control, is the way it's written here, which is a little...
Your Honor, can you give me a minute? Let me see how much time she has left on supervision. Hang on, we can look right here. DOP.
5/15/23.
Okay, we're extending it to 8.
5/15/23.
So we're extending it to 8/15/23.
Yes.
That'd be fine, Your Honor. So she'll have from now until 8/15/23 to be on.
Right? You understand how strict community control is, ma'am?
Yes, sir, I do.
You don't go visit your next door neighbor unless you've got approval from your supervising officer.
Yes, sir, I'm familiar with it.
Hands-on, your contact. Of course, we're now, I'm sure a lot of the IOTS stuff was in response to COVID, but now it's not quite so restrictive, so.
Yes, sir, I understand.
You'll complete all the original conditions of your supervision to the extent they've not yet been satisfied, including any remaining financial obligations. You'll have an additional $100 cost prosecution fee. You're entitled to a hearing regarding your attorney's fees. Do you need a hearing about a $50 application fee and a $100 attorney fee for your attorney? It doesn't go to him, it goes to the state for his office.
I explained that.
Yes, sir. Yes, sir, he did.
It's okay with you?
Yes, sir.
I find that you've waived your right to a reasonable attorney fee hearing. You'll be required to pay the $50 application fee if unpaid and the $100 public defender fee. And are there any other requirements here?
Not that I've been advised of, Judge.
None from the state.
And you're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. And I'm going to presume from the way you've been discussing things that you seemingly don't have any issues with substance abuse now.
No, sir.
Is that correct?
No, sir.
You do have problems with substance abuse.
No, I do not, sir.
I thought I heard you right.
I'm just making that clear. No, sir, I do
The point
not.
is that if you still have any urges, and that can happen at any time when you have.
That is very
in your
true.
life, you need to get yourself to a meeting, call your old sponsor if did you have one?
No, sir, I did not.
You might want to think about getting involved in that community anyway, because with your experience, you might be able to help others find peace and sobriety.
Yes, sir.
Thank you, ma'am.
Thank you, sir.
And Your Honor, her probation fees were originally waived. We would ask that continue to.
Granted.
And just to narrow the scope here, if she does have any outstanding fees, and I don't know that she does or doesn't, due to the short turnaround, we would ask that if she doesn't have any violations between now and 8/15 of '23, that any
Set up a payment plan with the clerk.
go to collections. Okay, thank you, Your Honor.
Thank you.
Advise of right to appeal. And your advisory right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed.
Yes, sir, thank you.
Thank you, Your Honor.
Thank you, Judge.
Thank you by staying clean and doing what you need to do here.
We just have, I'm just throwing stuff at you.
Who's next?
Just all the business that I have now. I will grant you, Ms. Moran, for example, was laid on relatively quickly, so if there's anything else.
I've got Swan.
I've got Ms. Boardman, Your Honor. Your Honor, Tim Gibbs on behalf of Wendy Boardman, 22 CF 1407. Your Honor, we're asking to continue this to February 28th without subpoenas. We're getting some evaluations done for treatment options for Ms. Boardman.
No objection.
Is that acceptable to you, ma'am?
Yes, sir, absolutely.
Granted.
Thank you, Judge.
Just looking at the docket, I'm showing originally Casey Ann Jordan Hooker was on the docket. My understanding is that private counsel was retained for her. Okay.
I do have an out-of-custody Judge, Misty Swan. She's present in the courtroom. May we call her case?
I do not believe she's
She does not
lying.
have an attorney.
She's unrepresented.
Swan, you come on up.
And Your Honor, I have spoken to Ms. Swan. I've advised her of her right to have an attorney appointed for her. She's here for a violation of probation arraignment. She has been charged with a technical violation of failure to report and a positive drug test. The state has indicated to her, she was originally on probation for possession of drug paraphernalia, a misdemeanor, and I indicated if she wished to resolve her case today, she could resolve with adjudication of guilt of that misdemeanor, credit time served, $500 fine, court costs and cost of prosecution. She indicated that she did wish to accept that offer. I did draft a plea agreement for her to read. She's had it all morning, so at this time, she indicated she does not wish to have an attorney, and she would like to accept the state's offer if the court's inclined to accept that offer.
Ma'am, how do you wish to proceed?
Do you just sign there if you want to have an attorney?
If it means that I'm going to be done with the jail and the probation and everything, I'll go ahead and plead no contest and take that.
I do want to remind you, you have the right to an attorney. If you cannot afford one, one will be appointed for you. If you qualify for counsel, there'd be a $50 application fee, and you're on misdemeanor probation, so likely a $50 attorney fee. But you would have them to assist you if you needed counsel. And It's alleged here that you've got some drug-related interactions back on June 30th with amphetamine and methamphetamine, and then some more amphetamines on November 14th.
Yes, sir.
Methamphetamine as well, or excuse me, a positive drug test for that. Failing to go to treatment, failing to pay some costs, failing to do drug testing fees, and
I'd already been to Bridgeway a couple times.
failure to report apparently back in,
That is not true.
so,
But I'll go ahead and take it if I can be done with it, but that part was not true.
well, the point is this, you're on probation for drug paraphernalia, and you've been here all morning, you've heard me talk to a lot of people about drug-related stuff. It sounds like a lot of it might apply to you.
Yeah, there's accurate and inaccurate information on all of it, really, but if I could just be done with it today, I'll just...
Here's my, and I need to go through this step by step. Number one is you have a right to an attorney. Do you want an attorney to assist you?
Not if I can be done with it today, sir, no.
We go this one step at a time. The state's made the offer. If you accept it, I'll go along with the state's offer. But the point is that the way you want to do it? You understand you're giving up your right to an attorney who could, and the point about not having an attorney is you might be waiving defenses or other legal issues that could assist you, and or they could negotiate maybe a different resolution than what you've been offered.
Yes, sir.
That's up to you, ma'am. The point is, once you give it up, and if you accept the offer and the court accepts it, then you'll have to do what you've agreed to do.
I'll go ahead and accept the offer with, but I'm not going to have anything but the one charge listed, right?
Well, you're here for a drug paraphernalia charge, but you've got multiple allegations of violating your supervision. And we're here to resolve those violation questions. You've already been found guilty of the paraphernalia charge. So this is a different question. It's a technical matter to go through the process of resolving your probation violation. Is that what you want to do? Give up your right to an attorney?
Assuming everything she told me is accurate, yes, sir.
Told you what I've said, so I need a yes or no answer about the attorney question.
Yes.
All right. And have you been threatened to give up your right to an attorney? All right. And anybody promise you anything other than what's been discussed here today? All right. And have you had any medicine, drugs, or alcohol in the last 24 hours? Ever been committed to a mental health facility? And you wish to represent yourself in this matter, understanding that you might be committing legal malpractice. If you were an attorney might be able to help you with things that you don't know about. You understand that? And you're willing to give up any complaints about that and represent yourself. And how far have you gone in school? And can you read and write? And you've been in the court system before. Have you ever represented yourself? But you want to represent yourself in this regard.
Normally no, but yes, assuming...
For today, for this issue, you do want to do that. Is that correct?
Assuming I can be done with it as she stated, yes.
Gotcha. I find that you've waived your right to counsel. And how do you wish to plead? All right. And what about having these dirty urine samples while you've been on probation? Were you using a little bit? I need you to answer, ma'am. You were using? You understand how bad that is for you? How dangerous it is for you, depending on what you're using? You know, meth is toxic. It damages your body in significant ways, especially if you get into chronic use. And the point is these drugs are highly addictive compared to a lot of other substances. You've got to get yourself into some effective treatment and figure out a way to stay clean and sober, to protect yourself and your health. What about failing to pay the costs? Did you have an ability to pay?
No, sir. I'm working on disability. Sir.
You understand you might have a defense of inability to pay.
Yes, sir.
You're waiving that defense by entering your plea. I think that's best.
Your Honor, I'm just going to have her sign the agreement.
One other thing we have not addressed.
May I approach with the physical?
The other thing we had not addressed was failing to report on October 2.
I don't even know where that come from. I didn't hear anything, nothing was said to me whatsoever about failing to report. I just seen it on the paperwork after the violation. I don't even know what that part's about.
Yeah.
That's inaccurate, and I'm hoping that, if anything ever happens in the future and I need to get a bond, I don't need an FTA on me.
The point is that there's not a failure to appear. That's in court, but not.
Yeah, but she said it would show up basically the same thing if that was, something like that were to happen, but I don't even know where that come from.
I'm going to consider that.
Judge, we can just proceed forward on the rest of the violations.
So it'd be 1, 2, and 4 in the remaining violations.
Sure.
And at this time, you'll find you guilty of violating your probation. You'll be adjudicated guilty. You'll be sentenced to time served. You pay $50 cost of prosecution, $50 court costs, a $500 fine, plus a 5% surcharge. You have 180 days to pay those monies. If you fail to pay, or if you're having difficulty paying before the 180 days is up, go to the clerk's office and set up a payment plan, okay? You're advised of your right to appeal within 30 days. You have the right to an attorney. If you cannot afford one, one will be appointed. Thank you, ma'am. We already do Chesser earlier, I think.
Yes, sir.
And then I have, right.
Your Honor, there is one individual, Mr. Sixto Rivera. He's listed under Mr. Timothy Shaw, but I believe Mr. Shaw and Mr. Flowers are both off the case, and Mr. Rivera is still present.
Well, I do have Mr. Rivera's name on the docket here, so Mr. Rivera, if you'll come on up.
I'm sorry, but I knew that one, so I figured I'd bring it up.
Yeah, that was the only one left on the docket. The clerk did
Okay.
the same thing I did.
Still see people, so I wasn't sure.
It's just paperwork.
What are the issues here?
Your Honor, Mr. Rivera, I believe, and correct me if I'm wrong, sir, has filed an emergency motion to dismiss criminal charges in this case. The state is asking that that motion be stricken. We believe it is facially insufficient, and it's not sworn to either.
What's the status of this case at this point?
Your Honor, as I stated, Mr. Flowers and Mr. Shaw had represented him. We have filed the formal charges in this case, so Mr. Rivera has been formally charged. It has been previously continued by prior counsel. Subsequent to their last appearance, I believe they filed a request or a motion to be relieved of the case, and the court, it's my understanding, filed that order, and signed that order. So we are currently still...
Conducted?
I'm sorry, sir?
Was there ever a Ferretta hearing conducted?
No, Your Honor, actually, there was not, and we are currently set...
Were they retained counsel?
Sorry, sir?
Were they retained counsel?
Yes, sir, they were.
Do you have that? Here, ma'am.
We would normally be on the next pretrial, I believe, which would be on 2/27.
Did put it by attorney. No, see if he's in here. Bert. No.
was entered late last month about a withdrawal. All right. So at this point, Ms. Rivera, apparently you did not have an attorney assisting you. They were-
I'm sorry, Your
Here it
Honor.
is right here.
Right, hear you.
That's this
Sure.
one.
Apparently at this point, you do not have an attorney representing you.
So, Your Honor, as the state stated, I had to fire the attorneys because they were, one of the attorneys, actually, this was a kind of conflict of interest because one of the attorneys was a judge in this case particularly, prior with the same person. So now wanting to work on my behalf and knowing the situations that were on it, I had to remove him from the case.
Well, I need to go through this one step at a time. I do
Yes, sir.
want to inform you that you do have the right to an attorney. If you cannot afford one, one will be appointed for you. Do you want the court to consider appointing an attorney to assist you in this matter?
Sir, to answer that question, I believe that based on my income, I do not qualify for an appointed attorney. Now, due to the situation with the current legal firm, the legal firm that I had to fire the attorneys, now I have to try to recoup due to the, what I just mentioned, the conflict of interest of the attorney that was appointed to me was a judge who had previously dealt with the situation going through with the current victim and myself.
The judge granted the motion to let them withdraw from your case
Yes, sir.
or to get them off representing you.
Yes, sir.
But the point is this. Do you intend to hire another attorney?
Right now, I don't have the funds to it, Your Honor. I can't. I have to fight with the other ones to, I guess, to recoup the
Well, I
funds.
could inquire of you to see if you might qualify for an attorney. If
We
you
could
want
do
me to
that, Your
try to
Honor.
do that. I don't know whether you would or would not.
I tried over there, but when I went to I believe, across the street, where the public defenders are, once I told them about my income, I would not qualify.
Chances are, I don't know what it is, but if you will, please raise your right hand to be sworn. Do you swear or affirm the testimony you give will be the truth, whole truth, and nothing but the truth, so help you
Yes,
God?
sir.
And state your name, sir.
Sixto Omar Rivera Rivera.
All right, Mr. Rivera, and you can put your hand down. And you're employed?
I'm retired. I'm disabled. I'm disabled, Your Honor.
In what capacity?
Military, 100% disabled.
All right. And how many dependents do you have?
I have 2 dependents, a boy and a girl, and right now, well, the current spouse, my wife, my legal wife, she is my dependent and also her daughter from a previous marriage. I have a child with her, and I have a child from previous marriage. Essentially, 4 people are my dependents right now.
And is she employed?
No, she never was employed while she was living with me.
And you're no longer living together, but you're helping support her.
So right now.
Is that right?
No. So we're no longer living together, but there's no support or anything because there is a prenuptial. I have a prenuptial filed 2017, which stated that she did not get anything from my property, from anything.
I misunderstood what you said. So the point is, what is your gross monthly income right now?
My gross monthly income is, well, from VA and military, I believe I make about $5,600 plus my rental property,
All right. And what's your income from the rental property?
$2,000.
And do you have a mortgage on those properties?
Yes, I got 2 properties, and both
What are
have
your
mortgages.
total financial obligations per month?
Between the mortgages, I believe, well, one is 17 and the other one is 14. 1,700 and 1,400, just over that, and plus the vehicle, which will be 11 something. Those were like the main bills that I pay, plus everything else.
Well, if you have a total of 2 dependents plus yourself, I don't think you would qualify. Is that correct with that income?
I don't know, we don't do that.
All right. Yeah, I've got it. So this is annual income with two dependents plus yourself.
3 dependents will be.
Who are the 3 dependents?
It will be 4 dependents plus myself.
Who are the four dependents?
Well, since although I'm not sending money, I'm still paying for health insurance for them, for her
Health
daughter
insurance.
and my
How much is
spouse.
the health insurance?
For the family, I think the plan is like, for the health is like $50, and then the other ones are like, for the vision and dental, between those two, I believe it's like 200 more, I believe.
Well, if you're getting about $5,600 a month plus about $2,000 a month for the rental properties, that's going to be $7,600 a month, so you'd be well over $64,940 a year. So you do not qualify for public defender services. So the point is, if you were to determine to hire an attorney, an attorney might take some other alternative arrangement about attorney's fees. And at any rate, otherwise, you would have to represent yourself. Do you
That's
understand
correct,
that?
Your Honor.
And how far have you gone in school?
I have a bachelor's degree in liberal arts. I was to start going to my master's degree, but due to the false allegations made here, I had to postpone everything because I'm not able to have my mind into the education, to further my education in my life and continue moving forward with my life while these allegations are lingering above me.
And that you can read and write?
Yes, Your Honor.
You understand? Trying to find the information here. Just a moment. It looks like you have charges relating to, looks like it could be third-degree felonies. Is that correct, counsel?
That's correct, Your Honor.
So, and plus a misdemeanor charge?
Yes, Your Honor.
Looks like you could face a total of 16 years in prison or jail, 16 years probation, a $16,000 fine, court costs or other consequences, if convicted of all charge. That's the legal maximum. Not that you would get that, but that's the legal maximum.
Excuse me, Your
So
Honor,
do you
I'm
know
sorry.
what the score sheet is?
Your Honor, I'm sorry, the one charge is actually an aggravated child abuse, so it's a
That's a
first-degree
second-degree
felony. A first-degree felony.
First degree. So that changes from 5 to 30 years. So there's
Your Honor,
as a legal maximum only.
thank you.
Not that that's the
Thank you
amount
for
that anyone would get if convicted. What would be this gentleman's score sheet if convicted?
Your Honor, I'm sorry, I don't have that handy.
Your Honor, if I may?
Just a moment.
Yes, thank you.
I'm trying to let you know what consequences you might face depending on how the case resolves. And have you had any legal education?
Was that, sir?
Have you had any legal education?
Legal education, not per se. I look into it, but not right now. I'm trying to continue moving forward with my life, and the person who accused me of this had done it in the past, and multiple times. That's why I'm trying to show this is...
Just, I would encourage you to not talk about the case, because if you say anything that could be...
No, I'm fine with to talk about it, Your Honor. I'm fine.
I just want to make sure you're aware that you have the right to remain silent. If you do say anything that is incriminating, it could be used against you.
Yes, Your Honor.
You understand?
I understand completely.
So the point is, we've got apparently your emergency motion to dismiss criminal charges, and the circumstances, you may have ways to work with an attorney to hire an attorney, and I would encourage you to consider doing that. These are serious charges that could have serious consequences if you were found guilty.
Your Honor.
And do you wish to do that or not?
At this time, I would like to present what I will have to continue with my motion.
You're saying no, you want to represent yourself.
That's correct, Your Honor.
And has anyone promised you anything to get you to give up your right to try to figure out a work out with an attorney?
No, Your Honor.
Have you been threatened, forced, or made to do so against your will? You had any medicine, drugs, or alcohol in the last 24 hours? What, other than prescribed medication?
Prescribed medication.
Prescribed only.
Prescribed medication.
Did you take that as prescribed?
That's correct.
All right. And have you ever been committed to a mental health facility?
That is correct.
You have been?
Yes, due to the false allegations that were made by the
How long did you stay?
It was outgoing, so I'll go every day, and I'll come back home every day.
So that wasn't really a commitment, it sounds like just more outpatient treatment.
Yeah, it was outpatient, yes. I had to do the outpatient.
And under the circumstances, I'll find that you freely, voluntarily, knowingly, and intelligently waived your right to counsel and elected to represent yourself in this matter.
Correct.
And we have the motion here. Was it set for hearing today on the emergency motion?
Your Honor, we're asking the court to strike that motion. We believe it's facially insufficient.
My question, was the motion scheduled for hearing today?
Yes, I did receive notification the motion was for schedule for hearing today, Your Honor. And actually, it had 2 hours scheduled for it. I don't know what happened with that documentation, but yes, I did receive documentation.
The state is prepared regardless of whether there was proper notice for today?
Your Honor, as I said, we don't believe we can proceed on this.
Different question, counsel. We're not there yet. Are you prepared to deal with it legally? Because I don't believe it was, at least in a quick scan of the docket, that it was properly noticed for hearing today.
The state is not, Your Honor.
So how do you wish to proceed?
Your Honor, if Mr. Rivera does wish it to be a 2-hour block, then we ask that the court set that on a date that's available, if Madam Clerk can give that to us.
Your Honor, it's been 9 months since the police arrested me after they stated that I was the victim and made the statement making the alleged victim stating that she was the aggressor. 9 months that I haven't been able to see my children because of the false allegations of these people. In fact, this woman actually accused me of raping her and sexually abusing my children in 2018. And I have all documentation here. Also, this alleged victim who was determined to be the aggressor stole over $10,000 in property from me. The state came here making false statements and I have all documentations here. That's why they're not prepared, because they know that they haven't followed up on anything and they've just been looking and listening to word of mouth. None of the evidence have been presented and it's been 9 months since I've been dealing with this nonsense, Your Honor, this injustice. Over $10,000 were still due to the false statements made by this woman while violating a court order in Liberty County, and I have all documentation here.
I do see in the file that there was a notice of cancellation of a hearing on the motion of withdrawal that was set today. Presumably that was because the order was entered in the interim. But without this having been formally noticed for a hearing today, I'll grant a brief, and I mean brief continuance. What is the docket for the 27th? Okay, and how long is that scheduled for? What hours? How many cases are set at this time? All right, what about on the 28th? All right. We'll set this matter for a hearing at 3 p.m. on February 28th. That'll be your hearing date. And
Your Honor, may I ask for a request, please?
What's that, sir?
And this is for my clarification.
Yes, sir.
You are, I guess you're the senior representative here of the judicial system. And I have an injunction here that states the petitioner needed to go accompany, to make coordinations with the police department and go to the property, meaning my property, to collect certain items, which the injunction states. Everything is by the court order. The alleged victim, which was the determined aggressor, is the person who violated that court order. I called the police. I made all those statements, and now the police tells me that this injunction for a petitioner is only a guideline, that person did not need to go to the property with the police, nor the police needed to make sure that she only took certain items as the order states.
Sure, I appreciate that, and you'll be allowed to present all those issues. The issue here, and we've got to go through this, and I apologize that it's taking time, but the issue here is there there was no formal hearing set for today. The one that was set for today was on a motion to withdraw, and that hearing was canceled, so.
I understand, Your Honor. I understand
And
now.
the state was aware and saw you were here today and informed me about the fact that this was a matter that needed to be resolved, and they need a brief time to look through this to get prepared, so it'll be February 28th at 3 p.m.
That's okay. I'm just, not only the state, the police department, everybody have made false statements which resulted in theft. And they don't even want to do anything about the theft.
Those will all be addressed at the hearing on the 28th.
Thank you, Your Honor.
Thank you,
I
sir.
really appreciate your time.
Thank you, Judge.
Everything.
All right. Is there anything else on the morning docket? All right, we have folks here. We do need to take a brief break for everyone to do things. We'll be in recess. How long do you ladies? All right, what's his name again, please? Last name?
Holden, H-O-L-D.
Is he here in the courtroom?
Yes, sir.
Marius Holden. Stay here on that matter. Mr. Holden, you were here this morning, and I'm taking your case up. It's after 1:30 now. I apologize for the long delay with the issues we had this morning. At any rate, an information has been filed, and I do want to advise you that you have the right to an attorney. If you cannot afford one, one will be appointed for you. You're charged with possession of firearm, ammunition, or electric weapon by a convicted felon. Those are 2 second-degree felonies where you could face up to 30 years in prison, 30 years probation, $20,000 fine, court costs, or other consequences. And do you want an attorney to assist you in these matters?
Yeah.
And you're for to hire counsel.
No.
Have you filed an application for counsel with the clerk's office?
No.
Do you have one with you there?
Yeah, I got one. I just filed it.
Hand that to the clerk, please. Are you ladies able to assess that today? Let me see it, please. Just bring it up. All right. I'm going to ask you to take it down after court. I believe the clerk will conclude that you do qualify for public defender services based on that affidavit, and I'll appoint the public defender. Public defender present, yes.
Under a not guilty plea at this time?
Requesting a time for pre-arraignment motions.
Yes, Your Honor, we would.
How long?
15 days, Your Honor.
Granted. Requesting trial by jury.
Yes, Your Honor.
Okay. Sir, there's a $50 application fee which should be paid within 7 days, and at the end of the case, you have the right to a hearing for about a reasonable attorney fee. Typically on felonies, it's a minimum of $100. Could be more depending on how much work the attorney has done and whether they request a greater fee or not. And you need to make and keep appointments with your attorney and to help your attorney help you.
Can we get our next court date, please? 2/27, okay.
We're going to take a recess until 2 p.m.
All rise. Now in recess for 1400.